Hello, everybody. Hi. I am really early. I know I'm really early. I'm sorry. I am not going to spend a ton of time on the usual introductions and hellos and everything because it's a 3-hour long case. And I just realized that I forgot to put it in the Discord. So I'm going to have to quick do that because I think people rely on the Discord more than they do the YouTube notifications. So I'm going to do that, but I'm going to put the case on. It is an awesome collection. Hi guys. I'm not gonna do a whole lot of time with the intros. Oh my god, that's gonna kill me. Oh, I see you guys coming in and I want to say hello to everybody. Oh, but it's a 3-hour long show already. And if I add on all of our hellos and our pre-chat, I'm not going to get out of here until 4 a.m. because you guys do that to me. But I put little breaks in between each hearing so we can kind of digest and process and talk about it for a minute. I can answer any questions. There's a lot of context that we didn't have in the first sets, in the first case. So the first case, we came in on, I think it was like April 23rd that it was run. So we came in on the end of it. All of this started a lot sooner than that. The first case that I have starts on December. Oh, no. Nope. January. No. July 23. July 23. A year ago. Forgive me. I've been doing this all day long. Okay. So I thank you. Lucy sent me 3 of the hearings. And then I went out and went on a rabbit hole. I sent Emily and Philip on a rabbit hole. Or down a rabbit hole. And it's been one of those days of collecting parts and pieces, stitching them together and editing them, and then voila, here we are. So I would never, ever say that. But if you say everybody, that includes me. Yeah, Tiana Miller. And I just wanted to say that tonight it is the first night that I am cross streaming on X. So I don't know how that's gonna go. I've never done it before. But so if anybody comes in here from X, hi. I'm so happy you're here. I want to welcome you right now. And I hope you enjoy this because this is what we do. Usually actually we do like a whole lot more, like 45 minutes of a whole lot more of talking about random stuff. So I know I said that I forgot to post it in Discord, and I'm sorry, because I think people rely on the Discord warning more than the YouTube warning because there's usually not a YouTube warning. But hello. I'm glad you found me anyways. Oh, hi, April. Okay, guys, I'm going to put this on because if I don't, I'm going to be here till 4 a.m. So this is the start of everything that, as far as far back as I could go, she wasn't even in custody at this point.
Okay, hey, this is in the matter of the Smith children, file 20545. All right, we're here today on a review permanency planning hearing and a motion to reinstate parenting time following an ex parte to suspend the bench conference. Just to briefly address whether or not we'll have a full hearing on that. And my understanding is we're just going to take the issue of parenting time as part of today's review. But I'll let the attorneys confirm that after appearances, beginning with our guardian ad litem.
Good morning, Honor. Ariel Berger here as the guardian ad litem for the minor children.
Ms. Sasha Thomas, counsel for the department.
Caitlin Young, Department of Health and Human Services.
Michael Brooks, I represent one of the fathers, Aaron Schmidt.
And Elias Muad, representing mom, Bailey Demansky.
And I am Bailey Demansky, mother of all.
Mr. Aaron Schmidt, I believe you are with us by Zoom today. Is that right?
Yes, I am.
Thank you. All right, very good. Counselors, could you confirm that our bench conference simply was about that, or give us any comments that you might want about that? Let's start with Ms. Thomas.
Your Honor, I simply to reflect that I had asked for a bench conference just to review the procedure for today, given that there was the motion in ex parte.
With the statements made by Ms. Thomas are correct, Judge, and what you said was correct.
Thanks.
I'm just along for the ride on Mr. Muad's motion, so I have no comment.
Ms. Berger.
I have nothing to add from our bench conference. I believe that we'll just hear any other motions with the review today.
Thank you. Perfect. All right. So then let's get to it. Your report, Ms. Berger, whenever you're ready.
Yes, thank you, Judge. I was able to do virtual visits with the families and the children this reporting period. BS is reportedly doing really well. He's growing like a weed. He's obsessed with dinosaurs. Placement was able to show me his dinosaur toy box and toys and bed and all of the fun things they got on a Prime Day. They do have a toddler bed that the agency has ordered there that they are waiting on, so they can transition him into that. He is sick again. That poor kid can't catch a break. He has strep throat right now. I think he's probably had every sort of sickness that kids can get from daycare and beyond in the last couple of months. But other than that, he seems to be doing all right. He has a full mouth of teeth. He's just waiting on a couple of molars. He's been to the dentist 2 or 3 times already. He is exceeding expectations as far as development. He's talking, he's running around like a crazy little madman. Placement reports that he's very coordinated for how young he is. He's not tripping and falling over himself when he's running around. That he loves going to the park. He loves eating. He seems to be doing really well with his placement. Likewise with the minor child MW, he is exhibiting less and less behaviors now. He seems to have stabilized a little bit more. He does still have some temperaments, temper tantrums, but his father reports that he is doing really well as well. He has filed for a friend of the court order, I believe, and I don't know that he's filed again asking for that to change since Ms. Demansky has pled in her criminal case, but I believe if not, he does plan to do so. So at this time, they are continuing to thrive in their current placements. Father Schmidt has not re-engaged. I did attend a family team meeting with him this reporting period, and he did seem like he was going to re-engage, but he did not. I don't think he's had any visits. Visits for mother have been suspended. So at this time, I'm just asking for those things to continue, that there be another review period set, and that we consider filing a petition for termination related to Father Schmidt. Thank you.
Thank you, Your Honor. If Ms. Young can please be sworn in to give her report.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Good morning, Ms. Young.
Morning.
Briefly, can you state how you are familiar with this case?
I am the assigned caseworker.
So you're providing foster care case management services to the family?
I am, yes.
And you provided a court report for today's hearing?
Yes.
And other than the court report, are there any attachments that you've included?
Just the case service plan. There was no service provider reports.
Okay, I can hear it.
Shouldn't have any more interruptions.
And as it relates to your court report or the case service plans, are there any updates or modifications that need to be made to the reports?
There is one that I do want to note. So on page 2 of the court report, section 2, under the placement information, B, best interest. I did have in there, it was a typo on my part. We're in the best interest section for BS to return to the care of his father. We do need to modify that to remain in the care of his current relative placement. That was a former recommendation for his best interest. But this time it's the only, I believe, update that I have.
Thank you. And in your report, you indicate that, do I already have YouTube? Okay. You indicate that the oldest child is with his father at this time?
Yes.
Okay. And the youngest child is in a paternal relative placement?
Yes, they're a licensed foster home as well.
And your report indicates that sibling visits may not have been happening because the youngest was sick, as Ms. Berger has indicated.
Yes, he's been really sick, especially like end of May through all of June. It's been like back-to-back things that they've been dealing with.
Since the last review hearing, there has been an ex parte order entered to suspend parenting time. Your report isn't necessarily, maybe I missed it, but it doesn't seem that you're offering an opinion as to whether to maintain that or change it. Do you have an opinion regarding parenting time?
This is kind of where I'm trying to weigh different options. So I kind of see where Ms. Berger was coming from with her recommendations as far as the suspension of the visits. I don't necessarily agree professionally on all of everything that was in that motion, especially in regards to an investigation that was underway. Ms. Demansky had nothing to do with that incident that happened in March that was referenced in that motion. So I don't necessarily agree with everything that was in it. Did we need to suspend visits? I don't know. I'm kind of mixed in the air. The visits were going very well. We didn't have any concerns with Ms. Demansky's supervised parenting time. I would have been fine continuing with those visits. I do understand, yes, she entered a plea agreement for the second-degree child abuse. I fully understand and respect her decision in doing that. I don't fully agree with suspending of visits. Now, as far as Mr. Schmidt, his visits were prior suspended by the courts at the last hearing due to his lack of participation and his refusal to participate. He's since re-engaged with me to try to, try to get back in services, but he's moved out of county. So we're just trying to figure out a plan of what he's going to participate in, try to get in touch with his attorney to discuss the parenting time for him specifically, because like I said, it was suspended the previous court hearing.
If Mr. Schmidt were to be permitted to have parenting time with his child, do you have an opinion as to whether there would be a risk of harm to the child's physical health or mental well-being?
I do feel that it's a concern that he hasn't been engaged for several months, and it was at least a month prior to the last court hearing, he stopped engaging in services and refusing to continue with parenting time. So it's been approximately 4 months, so he would have to be reacclimated into that supervised setting. We wouldn't go right to unsupervised, what we were doing prior to that. And so at this time, if we were to re-engage, it could very well have an impact on his mental health and well-being.
And as it relates to the older child, Ms. Berger had made a comment about the father potentially filing a change of custody. Do you have any updates on that?
I spoke to dad and stepmom this morning. The stepmom did try to go and refile that for him. He works nights, so she was trying to file it while he was sleeping. And they would not allow her to file it, but she's not the legal parent. So they're gonna go this Friday when he's off work, get that refiled up in Genesee County. They were filing for the full custody, from my understanding.
In both of their children's placements, do you believe that it is the least restrictive environment to ensure their safety and give them the most family-like setting?
At this time, yes.
And during this review period, have you had the opportunity to discuss the case service plan with both parents?
I have briefly with both parents. I was able to meet with Ms. Demansky at her placement, where she's currently residing with her grandparents. And then I also have met, as Ms. Berger stated, with Mr. Schmidt for a family team meeting separately. So we did kind of have a discussion of kind of what was expected, kind of what to look forward to for this court hearing, as well as, you know, Ms. Demansky's pending sentencing. So we did have a discussion about a variety of things that were coming up.
And you stated that Mr. Schmidt has not been engaged in services during this review period.
He has not. He had indicated that he was looking for a new therapist because he's since moved out of county. So the therapist he was going to was in Monroe County. He's now, I believe, in Jackson County.
And as far as Ms. Demansky, has she engaged in any services to address the issues that cause the children to come into care?
She's completed most all of her services. I think the last piece that we were waiting for was her sentencing, just to kind of see what was going on with that. And she was previously receiving supervised parenting time with that parent aid aspect intertwined with this. So because of visits being suspended, there's nothing further for her to complete.
Do you know if she's continuing to engage in any therapy or any other
If
services?
she was doing it on her own, she had already completed therapy through Catholic Charities.
And as relates to the benefit from the services, it's a little hard, I know, when parenting time is suspended, but do you have an opinion as to whether she's demonstrated any benefit from services?
Per discussions, I mean, she seems to be very remorseful of kind of what happened. We talked about some of the things. I mean, I think it was a significant situation where she was very overwhelmed. And, you know, she lashed out and, you know, we discussed a little bit of that. And could it happen again? We don't know. That's not, I can't predict the future, but, you know, I think this has definitely been a real eye opener for her to kind of see, and, you know, this is what's happened with her actions.
I would really hope that permanently disabling a child because you got angry and overwhelmed would be an eye-opener. And there was a lot of confusion. I was going to talk about this and I forgot. There was a lot of confusion about the last hearing that we had watched, which was the most recent one. The child that got injured was not her biological child. It was her boyfriend's biological child. And she was babysitting at the time, but you can't really call it babysitting because they were in a relationship, and sometimes she was the girlfriend, sometimes she was the fiance. So it just depends on what version they thought would get them the most sympathy at what time. But the child that was injured, the mother was the blonde lady that testified. There's only two fathers involved. There's multiple mothers as well. There's the blonde lady that testified at the final hearing, the one that we watched a few days ago. And then there's Miss Demansky, which is the lady in the black shirt in the very bottom corner of the top right square. So that's the defendant. And then as far as fathers, the the older child of hers, her biological older child, was placed with his biological father. So the dad took custody of the child. Dad stepped up and said, "It's my kid. Get him here. I'm taking him." Kudos. Her younger son, who has now been in the custody of the state and being fostered by her boyfriend's parents, so the biological grandparents, paternal grandparents, that child has been with them for almost the entirety of its life. The kid was about 2.5 years old at the final hearing. He'd been with the custody of the grandparents for 2 years, so it's all he knows. They are mom and dad. But her biological child was not injured. It was her stepchild, or future stepchild. But you will get to meet the father of that child.
This is how it's affect the kids moving forward. I mean, like I said, I can't predict what's going to happen at sentencing or anything like that. I think for right now, if she were to reengage in a supervised setting, I think she would be fine. She said she does very well during those supervised parenting times. The kids seem very receptive to her and they get excited during those visits. So like I said, I don't have a problem doing the supervised parenting times if that's for your work.
And what are the barriers to reunification today?
One of the biggest barriers, especially for Ms. Nancy, as I mentioned, she's pending sentencing. I don't know specifically what's gonna come. I think it's July 27th or 28th. So I don't know what's gonna be coming of that. And depending on what her sentence will be, we'll really kind of determine what we're going to be doing as far as our case, whether we're gonna file a petition or if we're gonna move forward, continue with that reunification piece, or if we change essentially even to a guardianship. I need that key aspect for her. As far as Mr. Schmidt, he needs to reengage in services. At one point, we were ready to reunify, and then I don't know what happened. Things just kind of escalated. He decided to step back. He needed some time, some space, and that was about 4 months ago. So there hasn't been any visits, no services, nothing in those 4 months.
And what is the current permanency goal?
Currently, the goal is still reunification, concurrent plan of action.
And is today's hearing, you're here for permanency planning hearing as well. Do you believe that it is still in the children's best interest to maintain those permanency goals for them?
I do. I think that we do need to consider a goal change, especially with a lot of the things that are going to be coming up here in the next couple of weeks. Like I said, there's a couple of options that we could take a look at, whether that's filing a termination petition or moving towards like a guardianship route. Those are some other options. I don't necessarily want to go for termination. That's not necessarily what these kids need. They need permanency, yes, but they also need mom and dad in the picture as well.
Is there anything else that you'd like to highlight from your court report or just from your knowledge of the case for the court today?
I mean, just to kind of touch base what Ariel was stating about the kids. I mean, these kids they're great kids. They really are. MW, he's full of life. He's got a big personality. He's very active. I did note too that he still is continuing in therapy services. It's just he's 5. It's very hard for him to engage in services. So they're doing the best that they can with that, trying to navigate everything. I do want to know just a quick update too, as far as the complaint that had come in back in March. I had to reach out to law enforcement to kind of see where they were at as far as their investigation of the incident. So it's my understanding they started doing some interviews. They're going to set up a CAC interview with MW potentially on the 26th of this month. And then we were going to, I got the go ahead from law enforcement is to go ahead and set up the CTAC evaluation as well for him. And we're gonna do that here in Lenawee, so Dad's gonna bring him down for that assessment as well. So there's a lot of things that are gonna be coming still in the future, as far as MW, as far as ES. He's still doing very well. Yes, he's had some setbacks as far as his medical needs. He's been dealing with COVID, he's been dealing with bronchitis, strep. So it's been an ongoing thing the past couple of months for him, just recovering, and he gets to feeling better and then he gets sick again. So this last week he was diagnosed with strep, and just poor little guy. I mean, he's hanging in there, he's doing good despite that. He did get assessed for early on services. He qualified for speech therapy, so he's gonna be starting with that. And it was my understanding come February, he should qualify for a possible IEP through Lincoln Schools near where he resides. So he'll get services within that school district as well. That could potentially follow through with him through later years in school. So, but overall, both boys are doing very well. They've adjusted very well to their placements. They have a good solid schedule and routine. And they're doing very well in their placements.
Thank you. Your Honor, I have no further questions of this witness and would move to admit the court report in addition to the case service plans as proposed.
No objection.
No objection.
Clarification, not necessarily an objection. Paragraph on page 2, paragraph 2B, there is a recommendation that my client's child be returned to him, which is 180 degrees different from what's on page 6, which says he needs to be warned that his parental rights terminated.
And so what I had indicated in the very beginning of my testimony is that that should read that he should remain in his relative care instead of being returned to the care of the father with those services. So just, that was our recommendation. That was a misprint on my end.
With that, I have no other objections.
Thank you, they are received. Questions, Ms. Berger?
I have no questions. Thank you.
Mr. Mawad?
If you just one, first of all, I appreciate your honesty. You've always been great to deal with. Have you done any thinking about if Judge Anzalone sentences my client to, say, the worst possible case scenario, I believe would be 6 months. Obviously, the judge has the right to censor probation, 30 days, 90 days, 6 months. And she's out in 5 months. Would you consider holding off on a petition to terminate and allow her to come out for reunification? Have you thought about that yet at all? And if not, that's okay. I just wanted to see what your thought process was if there's a short term of incarceration.
Like I said, it just really depends on what is going to happen at sentencing. We're not objectionate to continuing with reunification.
Okay.
But it's this key piece that's really kind of holding us up as far as moving forward with that.
Okay.
I mean, like I said, she's completed her case service plan. She's done all of that. It's just this key component. It's that last piece that we need to figure out and where we need to move forward.
Appreciate you. I don't have any more questions, Judge.
No questions.
Any redirect?
No, Your Honor.
Thank you for your testimony. Can you return your seat? Other witnesses?
Not today, Your Honor. Thank you.
Ms. Berger?
I have no witnesses, Judge. Thank you.
Mr. Mawad?
No witnesses, Judge.
Mr. Schmidt, is there anything you want to tell the court?
Not at this time, no.
No witnesses.
Comments?
Thank you, Your Honor. At this time, we are requesting the goal remain reunification with the concurrent goal of adoption, with the understanding that there will be further discussions pending Ms. Demansky's sentencing. And obviously, given the outstanding custody issue with the older child, and then the fact that the younger child is with a relative placement, I think that there are some opportunities to discuss different permanency plans for these children. And given that they are stable and in the least restrictive environment, we do ask that they remain there and continue this case out for another review hearing. Thank you.
As of today, parenting time for both parents continues to be suspended.
Your Honor, given Ms. Young's testimony, I think that it is appropriate to maintain that suspension pending the sentencing hearing solely because of the potential psychological harm of reintroducing during a supervised setting and then Ms. Demansky going away again, coming back. I think we should be mindful of that. And then also until Mr. Schmidt has an opportunity to engage in services, understand how to refamiliarize himself with his child, I do believe that there still is a risk of harm to the child that he would be having parenting time with. So we would just continue to request that suspension.
Okay, how does the department intend to address the issues that have arisen most frequently with Mr. Schmidt? I was just reviewing the file to make sure I didn't miss anything, frankly, and it looks like the initial removal petition and even the prior CPS history in this case all revolved around failure to protect and some other issues that had nothing to do with the recent struggles that Mr. Schmidt's had.
Your Honor, it is my understanding that parenting classes were part of the case service plan.
Can I?
Yeah, go
I'm
ahead.
sorry, Your Honor. I was like,
Sorry, I should have asked you why you were on this.
Oh, that's okay. I can further explain it if you're okay with me doing that. He did complete the Orchards program. I believe it was about a 6-month program. And that at that point, once he completed that program specifically, that's where that recommendation to return to his care with FRP services through Orchards was introduced. And it was at that point we tried to do the FRP services. He didn't engage with them, and then he stopped communicating with the majority of us. And the communication that we did have was very spotty. It was kind of inappropriate. Like he basically told me to F off. And it was like, I'm done. I'm done fighting. I'm done doing this. He didn't come to the last court hearing because he said he was done. I'm trying to get him re-engaged in services. He's since moved. He's got a new girlfriend. He's got a new job. He's trying to find a therapist in that area to kind of address some of the things that he needs to address as far as mental health, because he was expressing a lot of issues dealing with that aspect of things. So I think once he can get re-engaged and get into that mental health services and try to get back on track, I think he'd be in a better place to try to get re-introduced to his son further down the line. So I am in agreement with that with Thomas.
Has there been a substance abuse assessment scheduled for him, or any kind of reevaluation to discover what might have led to? Because I know there was a car accident and I heard the word relapse, but I was not aware that there was any substance issues with this gentleman.
We did a random drug screen with him and it was negative, so there wasn't any further concern with that. I mean, there was comments that was made by the relative caregiver, but outside of that, we don't have any solid evidence that there was any substance abuse concerns at all. He submitted the drug screen, and that's what we asked of him. If it was positive, then we would have addressed that, but that wasn't a concern at that moment.
I mean, to be fair, they did what they felt, most addicts they're not usually clean for their drug screens. So I understand them not feeling like they had to pursue it more, but the caretaker that gave them the information happens to be his father. So I think if anyone knew of a substance abuse history, that would be the person's word I would trust more than anything. So, yeah, when the person who says that he's relapsed is the dad, you should probably, believe that maybe there was a problem leading up to it. And at this point, they don't have the police report yet from the accident. They don't know what caused the accident. All they have is, the word of the dad. So, and we met him the other day. He was a lovely man. And yeah, I believe him.
I understand he was in a car accident at some point.
So it depends on what story you get. From my understanding, a deer hit him. And then he had to get his vehicle fixed. And I don't know if he was in another car accident, actually involving another vehicle, or I don't know specifically. I'd have to have that conversation with him again. But he ended up getting a whole new vehicle. And that's when he had moved, trying to kind of start over essentially. So I don't know specifics of what happened with that.
Will you look a little bit further into that in our next review
I will, yes.
period, including perhaps even find a copy of any police reports, traffic reports, or anything else around what's been happening? Those are pretty significant changes.
I can have that discussion with them and get more information.
All right, counselors, questions based on my questions?
No, not on behalf of myself or Mr. Mansky.
No, Your Honor.
None, Judge. Thank you.
No, yeah, thank you, Ms. Okay, onward to comments by Ms. Berger.
Yes, thank you, Judge. At this time, I am asking for parenting time to continue to be suspended. I am in agreement with the specification by the caseworker that we should keep that in place definitely until their sentencing. And I agree with Miss Thomas. And if we would reintroduce and then mom would go away again, it would create additional trauma to these children. So definitely, I want to see what happens at sentencing to see if I would change my recommendation regarding the continued suspension of parenting time. I also think that it may be time to consider change, at least for father, again, maybe holding off on mothers until after that sentencing. But I've said it before and I'll say it again. I really, really find it difficult and don't know if I would be able to ever recommend a full reunification at this point, specifically with the types of injuries that were sustained by this child. So I continue to have reservations there, even if case plan services are completed. So I think at this time, I just want to really see what happens at that sentencing and see if father is able to re-engage. But I am recommending that we continue with the suspended time. Thank you.
Judge, I appreciate it. I think more of my comments to the motion that was filed by Ms. Berger to get the suspension are just more of my comments and my observations, and you can make your decision. So paragraph 2, she says that Ms. Demansky, paragraph 1 and paragraph 2 have to do with her guilty plea and her admittance that she was guilty. I don't think it's ever been an issue during this reunification. She's never denied in this proceeding that nothing happened. I don't think that plays a part into the motion. There's other allegations that the minor child, BS, more importantly, exhibited severe behavior after visiting mother. Quite frankly, I haven't seen anything. I haven't heard anything as far as testimony is concerned, and I haven't seen anything to that effect. And it also says that the 3 older children that have been released from the jurisdiction have recently disclosed that they heard mother beating the brother and that he was screaming. It's the first I've heard of it. I don't know where Ms. Berger got that from. Obviously, some adult should not be talking to kids about this incident. I'm not saying he's Ms. Berger, so I want you to know that. That's not what I'm saying. She probably heard it from another source, and I just don't think that's correct. Then we get into some, I think, behavior that MW was sexually abused. And I appreciate Caitlin and her honesty that my client's not the target on that investigation. She's not being investigated for anything. Regarding any allegations that come out of MW as far as any CSC issues or violent behavior. Other than that, I just didn't see anything in her motion that corroborated any objective evidence of anything that Bailey has done wrong to merit the suspension. Yes, she's being sentenced by Judge Anzalone on the 27th. That is correct. And so I just wanted to make that a record. Obviously, your discretion on how you want to handle the suspension whether or not you want to wait, or if you want to do that, make a ruling today, however you want. It's fine. I just wanted to let you know my thoughts on Ms. Berger's motion. She's doing her job. I get it. I just disagree with the lack of objective evidence in her motion. That's all.
Mr. Brooks?
The comments are directed to my client, Your Honor, since I haven't spoken to him very much. Mr. Schmidt, when I first got this case, I thought this was going to be easy. I didn't have much of anything against you. The only thing that's kept you in this case, the only reason your child has not been returned to you is because in plain English, you haven't done anything. Now, if you want your child back, you've got to participate in this case, cooperate with the plans, and do the work. If you don't intend to do that, you're not going to get this child back. So I'm asking you to decide which way you want to go with this. Do you want to cooperate and do the work? Or do you want to just continue as you have and eventually, as is said in the report, wait for the department to file a motion to terminate your parental rights? Thank you.
No, the court finds all interested parties were given notice for purposes of today's review and permanency planning hearing, as well as the motion on reinstatement of parenting time. I suppose the only concern I have in restating parenting time is the behaviors that are reported to have been associated after parenting time, which is not necessarily uncommon for a child that has to see a parent and then not see a parent for extended periods of time. Clearly, that is stress for the child, but it's also important to maintain the bond between the parent and child. I do see also that we have some new concerns, and I say new, meaning new since the filing of the petition around the other child, MW. Again, these have not been directed towards Ms. Bailey Demansky, but that is her child. And we await further investigation on that point. We also continue to await an early on evaluation for the child at issue here, BS. I'd like to ask who we typically ask in these situations about parenting time. Should we, I think Ms. Brene Moore has made some recommendations for us before on parenting time. So if we could ask a professional on this to give us a recommendation, have a look at the case and look at parenting time for both of these parents with this child, I think that could be very useful. What the timeline is on that, I don't know, because I know our service providers are carrying very high caseloads. So I'm going to leave the suspension in place because of that potential risk of harm to the child mentally and emotionally, not necessarily physically. We have some outstanding questions to be answered on the sentencing. So I think because of those reasons and because of Mr. Schmidt's absence as well, that suspension will remain in place until we can have something from our professional. And even if that's a reintroductory type schedule, I'd like to see this done in a way that serves the interest of the child and secures against any mental and emotional risk of harm to his well-being, which I think is a risk at this point, given father's extensive absence and the sort of almost, well, the absence of mother based on the motion by our GAL, but also because of some, and some of those issues that he's having around parenting time. There's a request in the court report for an accelerated review period. So I would like to ask our other attorneys if they think that that would be useful as well.
Well, I think you mentioned Brene Moore. She's pretty backed up. So she's going to get sentenced next week. So that's good. Here's what kind of my thought process is. I'm not worried about getting something quick. I'll tell you why. I want to see what happens with the sentencing. And then maybe I file a motion to cope regarding what happened at sentencing and maybe for a request to get her parenting time. By then, hopefully we'll have more information on all these other issues. So I'm not sure what you're thinking as far as time, but I want it to be done right and thorough. And I want to make sure that I represent Bailey and not rush it.
So the earliest available review would be Monday, August 28th in the afternoon. But our regular review timeframe would be like October.
Your Honor, if I may.
I can land in September.
So let's do that. I may be in a continued CSD trial in Berry County, but listen, if something happens, we gotta move it for a week. You guys are always great on that, but I'd like to keep that date if it's good with Ms. Thomas.
You want the earlier one?
Yeah, we could, August 28th?
Yeah.
Or what was the other date, Johnson?
August 28th, I can go out from there. I've
What
got,
would be the next date after that?
well, I have an hour on the 30th at 10. And then going into September, it looks like I have Tuesday the 5th.
I would appreciate the 5th, so I'm out of my jury trial. Yeah, I can attend to that, if that works with the court.
Ms. Berger, do you have commitments on the 5th?
Sorry, September 5th, I'm available.
All right, I have 10 a.m.
That's fine.
All right, so let's set our next review and permanency planning hearing on September 5th. And so for the purposes of tackling the issue of parenting time, I'm gonna essentially just put in the order that I'd like a professional to be consulted and that the department follow the recommendations of that professional, even if we receive them before we come back. And of course, Ms. Berger, I'm sure will be vigilant as always and let me know if she disagrees with the professional's recommendations.
If the court set a
She's been
time,
vigilant. Sorry.
10.
10 o'clock.
10 a.m.
10 o'clock?
Yes, and you'll have your coffee ready for you at 10 when you walk in, okay?
Well, equally important as the time, as this court well knows.
September 5th at 10 a.m. for permanency planning and review hearing. Your Honor, as far as I'm concerned, that resolves your parenting time motion.
Yes, it does. It does, Judge. I appreciate you. Thank you.
May I just have a question for clarification, because this comes up quite a bit when we have suspension of parenting time and trying to gather information. If our option boils down to a bonding assessment, depending on the professional's recommendation, can the parent participate in a bonding assessment?
Yes,
Thank you.
because if that's a recommendation from the professional about parenting time, then to me, that's supported by the professional in making that determination. So
Your Honor, just to kind of further clarify, so we're already gonna get a CTAC evaluation set up for MW. Would it be appropriate that we do a bonding assessment as part of that? And that be that recommendation to fulfill that portion, and then work on getting the recommendation for BS through a different source?
So I think
Or
you've
should
got
we do it all together.
to unpack that a little bit. I would prefer that if it's gonna be for an AMOR, for example, that you ask her that question. If she would find that useful, if she thinks that that's a safe thing for the child as she makes her decision on parenting time. So in other words, if Renee thinks it's okay to do the bonding assessment, then do it. Now, if you're asking the CTAC evaluator to make the recommendation, then obviously it would be up to that professional. But contact between either parent and his child, I would like to be sanctioned by a professional. So, okay, does that make sense?
Yes. Thank you.
Any other questions on that point?
No, not on behalf of myself and Ms. Vinyas. She understands.
Well, I do find reasonable efforts are being made towards the goal of reunification. This is a complicated case. We wish Mr. Schmidt the best of luck moving forward. Hopefully he's able to tackle some of these things that have come up recently. And we'll wait for Ms. Young to tackle all of her homework assignments and let us know what the outstanding issues are moving forward and what services are being put into place for both parents in order to help try to remedy that in pursuit of our continued goal of reunification. At this point, that will continue to be the goal. We are getting to the point where I will have to make a decision on what is best for this child moving forward, and it will probably be within either this time frame or the next 60 days or so. But I agree with Ms. Young that permanency is important, but so are the parents of this child. And the ideal resolution here is to see one of these parents be able to provide a home for their child. So I'm not going to make a goal change today. I'll reserve that for our next review hearing. And I certainly find Ms. Young in satisfaction of her obligations as well as Ms. Berger. Thank you, ladies. There remains a significant risk of harm associated with returning the children of Ms. Bailey to her care for the reasons that we've articulated today, especially that outstanding question on what's going to be happening with her criminally speaking, as well as the need to continue to demonstrate progress on her case services goals. Mr. Schmidt's been absent, so I need Ms. Young to do some more investigation on that point, as I previously articulated. So I'm not gonna be able to return his child to him as of today. We have those outstanding risks that have been actually more recently identified that need to be addressed. So children will remain with the respective placements that they're in, relative as well as parent, pending our next review hearing, which will be September 5th at 10 a.m.
Thank you.
That's all for today.
Thank you, Jeff.
Thank you, Your Honor.
All right. So, what have we learned so far? We learned that the initial goal, even while the mother was facing these charges of, she pled guilty. She pled to this of disabling a child because she was angry. I don't know any YouTube safe way of putting that. All right. So I'm probably going to get demonetized already as it is, but I don't care, whatever. I'd rather bring you guys the cases. So, but I still do have to somewhat try. But we've also learned that the father has substance abuse issues. Shocker, shocker. And even so, we have learned that the initial goal is reunification. Even with the mom facing these charges, even with the dad being absent from the proceedings and not really showing to give a hoot. And I'm sorry, someone is very much trying to get your attention. So even with all of that, they still at this point are thinking we want to reunify the mom and the child, or the dad and the child. We want one of the parents to have custody. But we know in the end that's not how that goes. So, the next hearing was to be September 5th. That got adjourned. Sentencing was to have been July 27th. That also got adjourned. Now, the September 5th one got adjourned to December 7th, and that's where we are going to go next. The one that got adjourned from her sentencing, it was adjourned to a day that Judge Anzalone was not there. So another judge took it, and it was not broadcast. Or it was broadcast in a court that I don't have. So I can't give you that one. I can't. I'm sorry. I tried. Well, I can't give you those two. Emily went on that's the rabbit hole I sent Emily down, was please find out where her sentencing went, because I can't find it. So she tried. And I love you, Emily. Thank you. But now we're going to pick up on, December 7th. And it's the next hearing, and let's see if Dad has decided to step in at all. And then after that, just so you know, well, we'll get there. All right, I'm gonna hit play, and she's got to go out. I'll be back, guys. I'm sorry. Ugh, if I would only grab the correct mouse. And put myself back down here, hit play.
We're back. We've secured Ms. Domansky. Ms. Domansky, can you hear us okay?
Yes, I can hear you.
Thank you, very good. All right. Let's go ahead and get started then. Ms. Berger, your report whenever you're ready.
Yes, Your Honor, thank you. I was able to meet in person with the children in this case. I was able to make the trip up to meet with MW, and both children reportedly are doing great. There is still some concern with MW. There's some CPS investigations, basically related to like clean house complaints. When I was in the home, it was messy, but it wasn't anything that I was overly concerned about. I didn't call in and make a report or anything to that effect. Dad works nights, so it's kind of difficult with his off schedule. But it does seem that they are able to maintain and get that cleaned up a little.
Oh, she's frozen. Oh, boy. Okay, maybe we're frozen. Can you hear me now?
I can hear you.
Okay, all right. It cut out after you finished telling us about your visit.
Yes. My Wi-Fi is awful. Let me switch to my I'll hotspot really fast.
Okay.
Is that any better?
Yes, thank you.
Okay, hopefully that maintains. But I was able to visit the home, and MW is a joy to be around. He's very excited, lots of energy. He was showing me his toys in his room and putting, crowns and masks all over me. So that was enjoyable. And I was also able to talk with the caseworker on this case regarding MW as well, and his dad and stepmom. At this point, I believe that we can release him from the court's jurisdiction, or at least that's what my recommendation would be. He does have an order from the front of the court. He is filing to get that modified while mom is incarcerated. But I don't believe that there is a risk of harm as she is incarcerated for, I think, a year, at least 10 months, if not a year. And afterwards would be on probation. So I think that hopefully it would be appropriate to release MW from our jurisdiction. I was also able to visit with BS in person, and he is growing like a weed. He's very tall. He's talking a little more, he's signing a little more, he eats everything in sight. But he reportedly is doing great. His caregivers report that he's meeting some of his milestones. They do have some evaluations, and they are following up with all of those just to make sure, he's developing appropriately and on track as he should be. They tried to do a toddler bed with him. He did not like that. So they took that apart and kind of put that away for now. And they're trying to transition him to that. But he has not had visits with either parent, and the caregivers report that he has had lessened behavior since that has happened. So I think that is appropriate to continue on at this time. So I'm just asking for one more review with that child, and then for a goal change, and then for MW to be released. Thank you.
Testimony this morning, Ms. Thomas.
Thank you, Your Honor. If Ms. Young can be sworn in to provide her report, please.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Good morning, Ms. Young.
Good morning.
You have provided a court report for today's hearing, correct?
That's correct, yes.
And in addition to the court report, you've attached the case service plans. Was there anything else that you attached to the court report?
I also attached a police report that I found from Blissfield Police Department in regards to Mr. Schmidt.
Okay. And that incident did not happen during this review period, but did you just become aware of it?
Yes, this is one I was following up from the prior court hearing. We were trying to find a report that validated the car accident that he had reported he was in. This is the only one I found so far. I'm still trying to do some more digging for additional information.
And to the best of, I guess, your recap, does the court report corroborate his statement that he made regarding the car accident?
The court report or the
I'm
police
sorry,
report?
the police report. I'm sorry, the police report.
The police report appears to be kind of a separate incident, but I don't know if it's necessarily a part of it. It doesn't state anything as far as a car accident, but that his vehicle was stolen and used by a friend and it was brought back. But he was also highly intoxicated, according to the police officers in the report, so it's kind of all over the place.
Thank you. During this last review period, I believe we're sort of at a little bit of an expedited review period. Has there been, I guess, can you just briefly summarize each parent's level of compliance with and benefit from the case service plan?
As of right now, I mean, as I stated in the prior report period, Ms. Demansky was facing her sentencing. She was sentenced to about a year in jail. I guess she's supposed to be scheduled to be out 6/28 of 2024, I believe, or around that time frame. So she's, doing whatever she can as far as services within the jail. I did speak to somebody at the jail last week about what she has available to her, and really all they have available is mental health services, psychiatric services, and then AANA. And then if there's any other additional things that she could potentially participate in, she's aware that she can request those things or at least notify me, and I can try to put a referral in. But I mean, she's as compliant as she can under her circumstances. And as far as Mr. Schmidt, his visits were suspended, so there's no concerns as far as parenting time. As far as his services, I'm working and trying to send out a release. I just got back Friday afternoon from him signed for his therapist. He said he started a new therapist that he speaks to over the phone. I don't know if it's every week or every other week. He wasn't really able to clarify that. I did go out to see his residence where he's staying now in Albion with his new girlfriend. The home was appropriate. I didn't have any concerns with the home. But as far as services, really the only thing he's doing right now is the therapy services, and I'm waiting to verify what that looks like.
And what would be the barrier to reunification with Mr. Schmidt at this time?
At this time, because there's been a substantial amount of time since he's seen the child, his last visit, and I believe I did note that in the court report, was on 3/20/23, where he had made some rude comments to me and said that he was done. He didn't want to complete anything else. He basically stepped away and wanted me to not contact him. I did give him a couple of weeks just to kind of take a step back, see how things were going. I tried to reach out to him, didn't really get a whole lot of response other than I told you I was done. And he kind of left it at that. I did get back in contact with him when he reached out to me, I want to say in end of May, early June, stating he was ready to try to re-engage in services. He found a new therapist. That's at that time, like I'm still waiting to verify that information. So that's kind of where we're at with all of that.
Thank you. As it relates to the LJL's request to release MW from the court's jurisdiction under this case, do you have any recommendation on that?
I think we are ready to release, but just to kind of elaborate though, because there was that CPS investigation, Mick was involved. They concluded that we can provide some services in the home to try to help make sure like the home stays clean. As the courts are aware from prior court hearings, they lost a child, but I'll say about a year or two ago, that really has taken a toll on their mental health. We discussed that, talking about getting in some bereavement services or therapy services of some sort, just to kind of help with that, because it's a trickle-down effect where your mental health can affect your everyday well-being. And if that is in fact what is going on, it will kind of assist with keeping the home clean, making sure that they're staying on task as far as meeting Mason's needs in the home and any concerns with that. The department's also working on purchasing some storage stuff, such as like a storage shelf, some bins, as well as a toy box for Mason for his room, just anything that they can do to try to help with some of that decluttering process. So we are trying to do the best that we can from afar. We have a courtesy worker that's been in the home multiple times a month. They had that NIC investigation, so those workers were in there. But at this time, they do have that 50-50 custody order in place. They're aware that if they were gonna go for full custody, that they would need to do that. Has not been done thus far, so that order still stands with that 50-50. So at this time, as far as releasing him, we have no objection to that at this time.
Will those services that you've just mentioned regarding some of the in-home support stuff, can that continue with like ongoing work, or does the court need to retain its jurisdiction for that support to continue?
We may need to continue a jurisdiction, just either another short review period so that I can see if they have prevention services up in Genesee County. If they have prevention services, they could continue stuff voluntarily through that. We have that offered through us, through our agencies, so, but every county is different in what they offer. So I could look into that and see specifically that portion and kind of proceed with that if that's acceptable.
Okay. And during the last 2 months, has Mr. Schmidt's communication with you increased to the point where you have a recommendation regarding a reintroduction phase with his child?
Well, I consulted to Therese Langen over at Parkside. I had a verbal recommendation from her. She hadn't met anybody in this case, so I just wanted to at least kind of touch base with her, see what her recommendation would be as far as, you know, should we reintroduce the child to the respondent parents? What's the likelihood that we could do that in a timely manner based on, this is what's outlined in that psychological evaluation, some of those concerns, the lapse of the parenting time since March. Her thoughts and questions to me were, what is the status of his TBI? So the traumatic brain injury that Mr. Schmidt had sustained has really kind of impacted, and how has it impacted his everyday life? Is it realistic to reintroduce a child? Is he going to stay in the child's life long-term, or is it gonna be short-term when he gets overwhelmed again? So there's a lot of those questions that we have to get answered, and I think a lot of that's gonna be more through his therapist. So that's why I'm trying to collaborate with this therapist to try to get that information.
And to the best of your knowledge, is Mr. Schmidt receiving any services or medical attention for his TBI?
Not to my knowledge. I know his parents had access to the U of M portal to some of those records, and they had indicated that he had missed several appointments. I don't know if he switched doctors or anything like that, but that's some of the stuff that I want to try to follow up with him to get more information on, because he was seeing a specific doctor at U of M. So the child and the dad's portal is all in the same, I don't know, the same access to it. So they were able to see that he had missed those appointments and were concerned.
And as it relates to mother, given the length of her incarceration or in the limited services available, are there any services or supports that you can provide, whether like through a hard copy parenting book or mailing things and getting her like a self-addressed stamped envelope to mail back? Is there anything like that that the department can do to support the current goal of reunification for Ms. Demansky?
Absolutely. I can talk to the jail and see what they'll allow me to send over there, as far as the stamps, envelopes, all that kind of stuff. Because sometimes since COVID, I mean, they've been really picky on what they're accepting in there. So I will discuss that with the jail again and see what she's allowed to have access to. And I can continually send some things over there. I have no problem with that.
And at this time, you are not asking for a change in the permanency goal, correct?
I'm recommending consideration of a goal change. Not necessarily to change the goal at this time, just the consideration.
Is there anything else that you'd like to highlight from your court report for the court's attention today?
At this time, I can't recall anything else that I would need to elaborate on.
Okay, I have no further questions, John, and we would move to admit the court report with the proposed well, I guess with the continued case service plans and the attachment. Thank you.
Now, the lady that's on the stand, we heard from her the other day, and she, let me tell you, I have never seen someone so thorough, not only with their documentation of things, but also with their recollection of things. I don't know if it was the one that we had watched or if it's going to be in one of these sets, but at one point, one of the attorneys was trying to get her, and like giving her incorrect information, we'll just say, and she spot on kept correcting it. And it was just wild to hear, you know. I mean, he'd give her the wrong month and she'd say, nope, February or whatever it was. And, you know, it just, she's so thorough. She's so good at her job. And I wish that we could clone her 1,000 times because she's so necessary.
No
No
objection.
objection. No objection.
Thank you, they are received. Cross-examination, Mr. Marwan?
Just a couple of questions. I know that we talked a little bit over the phone regarding Bailey and her future. I'm not hearing that it is your desire to recommend termination at this point. Is that correct?
Correct. There's a couple options that we could explore, termination being one, guardianship would be the other.
Yeah, we did discuss guardianship. Okay. And is that something, so you want to obviously keep jurisdiction for these kids regarding Bailey? That'd be correct.
Correct.
Okay. Thanks.
Questions?
Where is BS? Who is BS living with now?
He's currently residing with his paternal grandparents.
And how old is
He just turned 2.
he? And to your knowledge, when was the last time my client saw this boy?
March 20th, 2023 was the last report that I had.
And when is the last time you actually communicated with the father?
Yesterday. He sent messages back over the weekend.
Do you know why he's not here today?
He is at work and was not able to get time off, and they wouldn't allow him to go into the break room to participate by Zoom.
That's all. Thank you.
All right, any questions, Ms. Berger?
No, Your Honor. Thank you.
Okay, any redirect, Ms. Thomas?
No, Your Honor.
Thank you for your testimony. May you return to your seat. Any other witnesses?
No, Your Honor.
Mr. Mawad?
No, Your Honor.
Mr. Brooks?
I do not.
Good. Ms. Berger, anybody you'd like us to hear from today?
No, Your Honor.
I look forward to comments and closing then, beginning with Ms. Thomas.
Thank you, Judge. At this time, it seems that Mr. Schmidt is back in communication with the department, and it seems that there needs to be further communication regarding treatment for his TBI and whether it is appropriate to continue towards reunification for the child. And it also, I guess, is in part due to mom's incarceration. Although it's not very lengthy relative to some of the other cases that we see, I think it's appropriate to look into some of the potential permanency goals. And as Ms. Young stated, you know, maybe guardianship is appropriate at this time, but we are talking about a toddler who has spent a significant amount of time away from his parents. And so I think that during this review period, those things need to be explored. As always, the continued efforts towards reunification will continue. And as it relates to MW, I would request that we maintain jurisdiction during this review period to ensure that whatever supports are needed to maintain his safety can be provided, at least through our case and through the funding available in that regard. And then hopefully at our next review hearing, we will either have a court order or know whether those voluntary services are available in their county. And with that, we would just ask for another 90-day review to explore potential permanency options for, I guess, both children. Thank you.
Ms. Thomas, could you articulate for me any outstanding reasons why you that you see here that we could justify further extension of reviews, considering the fact that the child that we're really talking about, BS, was removed 3/26/22, clearly over the 15-month time frame, and really only under extraordinary circumstances is the court allowed to extend jurisdiction without consideration of the permanency and stability needs of this child.
Your Honor, while Ms. Demansky was not incarcerated, she had continued to make progress in her case service plan and complied with it. As far as a compelling reason, I cannot articulate one at this time. I think that for a majority of this case, we were waiting to find out what happened with the criminal charges. We were not sure if she would have any incarceration at all. But as it relates to Mr. Schmidt, given the lack of progress still and the inconsistent communication, I think as relates to him, at least we also don't have a compelling reason to continue towards reunification. Thank you.
Mr. Mawad?
So I am the child MW, correct?
The child at issue really here today, and I can tell you, I concur that MW, who's placed with non-respondent father, will likely be released. That seems to be in his best.
I don't have I was gonna say, I really didn't have an objection to that because it sounds like the friend of the court is gonna handle some of that, if not all of it. So that's what I wanted to say. So as you know, my clients did receive a sentence for 12 months with the time. She gets out in 10 months. It's not a prima facie termination. I'd like to see a guardianship if I can on this child to see what happens. I'd like you to keep it open, but I'm hoping the court doesn't terminate, not at this stage. But I like to see Bailey have some chance when she gets out of jail to reunify with these children some way through court supervision, whether it's through the friend of the court, whether it's through probate court, through a guardianship. That's what I'd like to see. I'm not sure what, obviously you're gonna let me know what you think, but I'm hoping the court doesn't terminate. That just might be. Thank you.
Ms. Brooks?
I can't, in all honesty, make an advocate for my client in this matter at all. I haven't spoken to him in months and months and months. So I don't know what his position is. The last one I heard is the one that was testified to by the department, which wasn't helpful to him continuing this matter at all. Quite the opposite, in fact. So if he's re-engaged, I really don't know about it. I too. So, but the direct answer to your question, do I have any compelling reasons to proceed with this case any further? No.
Ms. Berger? Oh, maybe having connectivity issues again with her on her end.
A bit, Your Honor. Can you hear me?
Yes.
Okay, thank you. My office Wi-Fi is crazy this morning, I guess. At this time, Judge, I don't think it's a secret that I have been requesting a petition for termination for quite some time. I don't believe we have to move forward with MW, like I stated previously. I think that Dad is securing a new order. He's with a non-respondent parent. The respondent parent is incarcerated. They're not getting any parenting time. But as far as BS, I do believe that at this point we can change the goal. I think that enough time has passed, quote unquote, waiting on the criminal case. And at this point, I have a hard time.
I pressed the button so you couldn't hear it on this job.
Can you hear me?
Yes, now we can.
Where did
It
I?
cut out after you said, at this point, I can't.
Yes. At this point, I can't see a reasonable, anything to grant a reasonable extension. We have a parent that has completed case plan services, has been compliant, but at this point is in jail for harming a child who is facing lifelong and long-term consequences from his physical injury. So at this time, I am asking that there be a goal change and that the department be ordered to file that petition for termination. Thank you.
All right, well, the court finds all interested parties were given notice for purposes of today's hearing, and that reasonable efforts towards the goal of reunification have been made, as well as recognizing the diligence of Ms. Berger in satisfaction of her obligations as guardian ad litem. Thank you,
Thank you.
ladies. The court does agree that it's in the best interest of MW, who has been placed with his non-respondent father, who's a parent with legal rights in this case for a significant period of time. And although we've had some investigations, I also trust our guardian ad litem in her observations that these are not issues that should cause the court to intervene with the family any further, as well as the observations made by Ms. Thomas that during the testimony of Ms. Young, that those services that are in place to help support Mr. West in remaining successfully reunified with his son are in place and will not be affected by the release of this child. It will be the order of the court that MW is released from jurisdiction of the court into the primary care and custody of his father, Cody West, who will continue to be directed to secure a custody order. However, I do find that the custody order, even though it is joint at this point in time, does not pose a risk of harm to this child anytime soon, given the fact that the respondent parent, Ms. Bailey, will be incarcerated for a period of at least the next 10 months. So for those reasons, there is no immediate risk of harm to this child, and he will be released from the court's jurisdiction. Now, if Mr. West does not secure his custody order and this remains outstanding next June, I'm sure he can look forward to the department knocking on his door. So I hope that you will take that seriously, Mr. West, and continue to pursue court orders that will maintain the safety of your child in the future. As it relates to BS, as the court indicated previously on record, this child has been removed from the care and custody of parents from March 26, 2022. I want to say, I think it's great that Ms. Young has put enough time, effort, and consideration into this case to rightfully observe that Mr. Schmidt's limitations as a result of his TBI may be contributing to the issues that caused him to be absent from his child's life for a period of approximately 6 months. But my job is to look at what is in the best interest of the child. Under the statute, abandonment is only a period of 90 days. He's far and away clearly been absent with the intentionally absent, may I say, from the life of his child for a period of nearly 6 months at this point in time. He has engaged in some recommendations, but not all recommendations, benefited somewhat. But at the end of the day, he must show us that he's willing to be there for his child. And what I have observed is that he is not willing to do that. So for those reasons, it will be the order of the court that the termination of parental rights petition be filed as it relates to his parental rights, looking at the goal of adoption for the child BS. I also have to recognize in the same vein that Ms. Bailey Gomansky will be absent from her child's life for the next 10 months. So despite some of her recent progress on some of those issues that surround the initial causation that brought this child in care, I also have to recognize that those allegations of severe abuse at the hands of his mother are also now the cause of a period of incarceration for the next 10 months. I cannot ask this child to wait another 10 months to have a parent available to him. It's not in that child's interest to do that. So for those reasons, the goal will be changed to adoption. If the parties wish to explore guardianship, I will never stand in the way of that. But as I can see here today, I'm not sure how the child would be able to benefit from a guardianship. That is something that is shown to be appropriate where we have a parent whose relationship with the child is a point of resiliency and support for that child. Ms. Demansky has been engaged with services and visitation as well as she's been able to. However, that has not been shown to be a compelling reason to look at guardianship, but I would certainly support the department exploring that and any other avenues that may be in the best interest of the child pending our next review hearing. But I have to look at his needs, the trauma that he's been in, and the stability and permanency that he needs, and whether or not there would be any reasonable period of time that we could look for Ms. Demansky to make adequate progress. And I do not find that 10 months is a reasonable period of time. So for those reasons, the goal has changed to adoption for this child. The court will order that the department file that petition within 30 days of today, have that timely filed and served by our next review hearing, which will also be the date and time for that termination trial on November 13th, commencing at 10:30 in the morning, assuming Mr. Mowad's available.
Should be available. May I make one correction?
Sure.
The victim in the criminal case was not her child.
Thank you. You're right.
Okay, that's, it's not gonna change your mind, but I just wanted to just make that clear. And November 13, sounds right. I got a ton of trials between now and then, but we'll figure it out. If there's an issue, I'll let the court know.
Yes, let me know as soon as possible.
All right.
And we'll look for a different date if necessary, because my assumption is that you would need more than an hour and a half. And so I've scheduled this for beginning at 10:30 and going to the end of it. But if you don't think we're gonna need that much time, perhaps you can let me know.
Okay, will do.
All right, in the meantime, he will remain in the care and custody of his relatives under the temporary jurisdiction of the court. That is the safest and least restrictive place for him at this time, given the unavailability of both parents at this time. Absence of his father, as well as the incarceration of his mother, being the primary reasons therefore, in addition to the rest of the reasons that the court has explored. Unless there's any questions, that's all for today, and we'll see you all on the 13th.
The trial is, can we just jump to best interest? Is that what we're dealing with?
It'll be a review, and typically
Okay.
the review is consolidated with the termination trial proofs because the
Okay.
allegations will be
Perfect. I
in
got
the
you.
statute.
I got you. Okay,
And
very
then permanency planning in case something happens between now and then.
okay, thank you.
You're welcome.
Well, that was pretty wild so far. So that's where it has switched from the goal of reunification to the goal of adoption. So here that was 4 hearings in when they made that decision. Well, in one of the hearings, like I said, one of the hearings was her sentencing, but they were waiting on her sentencing. And her lawyer was optimistic she was only going to get like 6 months. I'm really glad that the judge gave her the 1 year at least. It should have been so much more. It really should have. It should have been so much more. But, yeah.
Okay, here we go. All right, we're on record for purposes of a review in this file, 20-545NA. May I have the names of our participants, please?
Good afternoon, Your Honor. Ariel Berger here is the guardian ad litem.
Nastasia Thomas, counsel for the department.
This is the January 29th review date hearing. So this is still the mom. And then the one after this is the dad.
Young. Caitlin Young, Department of Health and Human Services.
Michael Brooks, I represent the father, Aaron Schmidt.
Your Honor, Counsel Elias Muad representing mother Bailey Demansky.
All right, Mr. Brooks, have you heard from your client since the last court appearance?
No, I have not.
Now remember that. He did not hear from him in the last one. He didn't hear from him in this one. They keep talking about how much he has not been involved. Just remember that.
Okay, and we'll get to Ms. Young's testimony in a moment. She can tell us any information she has about either parent. Mr. Mawad, would you like to address your
Oh,
client's?
take it back. He called me Friday. I'm sorry. He did call me Friday and ask about the hearing on Monday, and I said it had been adjourned to another day.
Okay, thank you. Mr. Mawad, would you like to address your client's absence?
Your Honor, she, as you know, is locked up at the Lenawee County Jail for a 1-year sentence on a child abuse charge. I would waive her appearance. I'm not objecting to any of the testimony that's going to come in today. I've seen the reports and they're all good.
All right, thank you. We are proceeding today after a scheduling, I used the word kerfuffle during the bench conference, so I'll use it again, which confused everyone as far as the termination trial date and the review hearing dates. So this review hearing was scheduled rather hastily, but needed to occur timely. And we have discussed some new trial dates at sidebar. Anything else about the sidebar, counselors, before we get started?
I'd like to know if he has been notified of today's hearing.
Okay, well, we'll ask Ms. Young that question in a few minutes, if that's okay. Anything else about the sidebar, counselors?
No, Your Honor.
Nothing to add, Judge. Thank you.
No, Your Honor.
All right, very good. As it relates to the review then, Ms. Berger, I look forward to your report.
Yes, thank you, Judge. I was able to visit with BS in person during this reporting period. He again was sick when I was there, hand, foot, and mouth this time. He is often sick, but the is looking into maybe changing daycare to see if that would help. As soon as he gets healthy again, they send him back and he comes back with something else. So I know that we are looking into that, and I've been working with the caseworker as well about funding for that. So other than that, he is growing like a weed.
Can you imagine this poor little boy in the custody of these two parents with all of these different illnesses that he's acquiring? He's obviously got a compromised immune system of some type. Because I just can't imagine him catching everything under the sun otherwise. But when you meet the dad, and when you well, you already met the mom, but just keep the little boy's illnesses in mind and imagine reunification of that boy with these people.
Very tall. He knows his colors. He knows numbers. He, loves to color. We had little paint pens when I was there last. He is talking, not as much, but he is talking. He loves the water. He likes to, play in the sink or in the bathtub, or he would take, 10 baths a day, they say. He still is working on transitioning fully to a toddler bed. And they are keeping an eye out for any other developmental, I guess, not delays, but maybe milestones that he isn't quite reaching. He just looks so much older than he is because he's so tall. He's so big. But other than that, he is perfectly bonded to where he is. He sees them as his parents. He's happy, he's healthy. They're meeting all of his needs. He is getting sibling visits with his siblings that are not in care any longer. They're getting to spend holidays together and birthdays together. He's also able to see his maternal grandmother, who also goes to Placement's home, which is paternal grandparents. So even the extended family is trying to work things out, so they are all able to be involved in his life and to provide support for him. So at this time, Judge, I'm just asking that we continue towards the goal of adoption and finalize any dates we need to do that. Thank you.
Thank you. Ms. Thomas?
Thank you, Your Honor. If Ms. Young can be sworn in, please.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. Thank you. Ms. Young, you prepared a court report for today's hearing that included the case service plans for both parents. Is that correct?
That is correct.
And we acknowledge that was just circulated yesterday, correct?
Correct.
Are there any updates or modifications that you are aware of that need to be made to any of the documents that you provided?
Not that I'm aware of. I put everything in there kind of based on, what we've kind of reviewed over the reporting period. I was able to meet with both parents at least monthly to kind of go over any updates they've had. So I tried to include as much of that as I could in here. I did have a conversation with Dad this week just to let him know that we were waiting to kind of figure out the new court date, and I would send out the court report and the information as soon as I got that. So I did have that, and I sent that to him. He said he had to work. He wasn't able to get it off. So, which is why he's not present today.
Okay. And at this point in time, has there been sufficient progress to reconsider the goal of adoption for this child?
As far as services for parents, I mean, they're not able to really do much. They don't have a bond with this child. They've not had contact with him in a majority of this year. So Dad has not had contact with BS since 3/20 of this year. Mom, his visits were both suspended back at the end of May, as the courts were aware. So they're not really able to work on that relationship. We do have those monthly case conferences, so we're able to have that communication on how BS is doing. If he's had sick appointments or well childs, we have those discussions. we're discussing, the milestones that he's meeting or he's not yet meeting. So we are having those conversations. They are aware that we are seeking termination of parental rights based on, the lack of progress and then mom's current incarceration due to the child abuse charges. So they are aware placement is in support of the adoption. They are willing and able to provide permanency for him through that adoption. And mom and dad are both understanding that that's what we are going towards.
And so to summarize, is it fair to say that there has been limited or no compliance with the case service plan during this review period, or is it just status quo? I know that for mom, it's a little hard there, but can you just highlight, I guess, from the report, the general compliance with the case service plan?
I mean, as far as overall compliance, I mean, they're both doing, what they can at this point. Mom's very limited on what resources that she has in the jail. Since COVID, they haven't reinstated a whole lot of services, but she does have access to mental health services as needed. So she seeks that out. She's trying to participate in whatever group that she can. And she's also participating in like a work program where she's like the head person that kind of cleans the unit, takes care of things. So she's able to, earn money towards paying her fines and her jail stay. So she is able to kind of do what she can. She's, aware of the situation, circumstances. She did write some letters for both of her children. So I provided BS has when I was at my last home visit at the end of November. So he sent some pictures, a sweet little letter to both of the boys. So I provided those. Dad, he's participating in therapy services. We still are dealing with, I will do stuff if I have to, but I'm going to do whatever I have to do to try to get my child back. It's not focused on what can I do to try to make changes so that I can have him live with me and make it a safe environment. So we've had several of those conversations. The attorney and I, the three of us have met since the last court hearing to kind of go over, what steps we needed to take. So, and as the courts are aware, he has completed a parenting class previously. We had tried to set up reunification services. He failed to comply with that. And ever since that time frame, beginning of this year, he kind of dropped off the face of the earth for a few months. So, we've been trying to build that relationship back up between the worker, myself and him, trying to, make sure that we are on target, if reunification is still going to be feasible or not. But at this point, he has a home that has a safe environment for him. He's got a bedroom set up in the event that he would be returned to his care. He's somewhat has a plan as far as childcare in the event that, we would have to explore that for reunification. So he has a good support system where he's at. with his fiance and her family. He's got a steady job. He's provided that income periodically as needed. So, we've been maintaining that communication. He's been compliant with what he can. Obviously, the issue is there's no parenting time. So he can't really work on that bond with his child if he's not able to see the child. So
Do you believe that there would be a risk of harm if Mr. Schmidt would have parenting time at this point?
I think right now, because of the amount of time that he's not had contact with his son, it would be difficult because he doesn't know him necessarily right now as that father figure. He hasn't seen him since March. He's 2 years old. And, it would be a struggle to try to reintegrate those parenting times back in. I mean, I think it's doable, but it would take some time for him to get used to his father again. The other issue is, the child is placed with his parents. He does not have a relationship with his parents right now. So all of that communication is going through the agency, through myself. So, it would be a lot of playing that middleman, going back and forth, similar to, a general foster home. So, it would be just kind of trying to pick the pieces back up and trying to build that relationship up again.
And to clarify, your recommendation is still adoption, correct?
That is correct.
Is there anything else that you have not been able to touch base on that you would like the court to know?
I don't believe so. I believe I've touched base on everything. Ariel made a good point about how well Braden is doing. He's very bonded to the home, and to his caregivers. He's able to see his siblings, and have that relationship still, see the maternal grandmother. So they've been able to maintain a lot of that contact with the extended family and so forth. But he's still trying to make improvements in speech. He still struggles with some of it. He's got speech twice a month, so one in the home, one at daycare. So he's making progress, slowly making progress in the speech area. But overall, I mean, he's doing very well. He keeps, catching, as Ariel stated, that he keeps catching just about everything under the sun that you can think of at the daycare. So, between hand, foot, and mouth and croup, he's had COVID, he's had, all sorts of illnesses all throughout this year. This poor little guy, I feel like he's been out of daycare more than he has been in daycare because he's been so sick throughout the year. He's got multiple wellness visits, checkups, hematology, eye doctor, all of that, just, to make sure that all is well, and he's progressing in that manner. So, but overall, I mean, everybody's doing what they can. Braden's doing very well. He's making those improvements. He's very bonded to placement. So.
Okay, thank you. Your Honor, I have no further questions of this witness and move to admit the court report with the attached case service plans. Thank you.
No objection.
I have
Just-
no objection.
Couple questions, if I can, Judge, to Ms. Young. I have no objection to the report. I think what you're recommending adoption is because of the length of time both dad and mom have not been able to be a parent to that child. Is that, Caitlin, is that what I'm understanding? Is
Yes.
that your thought
That's,
process? Okay.
that's one of the big reasons. Yes.
Okay. A lot of times, would you agree, though, that when that happens, but there's a impetus to have the mom and dad stay in the person's life, you would slowly and gradually allow the child to visit with the mom or dad, but through supervised and then independent without supervised. There's a way to reinvigorate that relationship if it had to be. I don't know what's going to happen, obviously, in the future, but you've done that before, correct?
As an agency, yes, we have. I mean, it's like I said, it is doable. I think with the concerns that placement specifically has is the extent of the charges. They've been through her whole trial on the criminal side. They've heard the evidence. They've heard her statements. They're very worried and concerned that, something else is going to happen to this grandchild or another child. So their biggest concern is they're very hesitant to have her in his life long term if this is something that she's been formally charged with. Something she's admitted to doing, and it's concerning.
Well, let me ask you another question. Are there people that you are aware of that have any child abuse convictions for either a misdemeanor or a felony in this case that were reunited with their children? in the past?
I don't know necessarily with my cases specifically. There has been some previously. I mean, I can't attest to the exact cases or situations, but
That's fair.
it's possible, yes.
Okay, that's fair. I don't have any more questions and I have no objection to the report.
Thank you. It is received. Questions, Mr. Brooks?
I just want to confirm, Ms. Young, that you personally told Aaron Schmidt about the date and time of the hearing we're conducting right now. Did you do that?
Yes, I did. I called him and I sent the email to everybody with the date and time with the court report. So it has been served to everybody, including your client.
When you called, did he personally answer the phone or did you leave a message?
He answered.
Thank you. That's all.
Any other witnesses or redirect? Ms. Thomas, or I'm sorry, Ms. Berger, did you have any questions for her?
I do not, Your Honor. Thank you.
All right,
But I
back
have
to you,
nothing
Ms.
for
Thomas.
this, Your Honor.
Well, anyone else you'd like us to hear from, Mr. Mawad?
No, Judge, I appreciate it. Thank you very much.
Mr. Brooks?
No, Your Honor, I'd simply ask you to confirm for me when, in fact, Mr. Schmidt's termination hearing is going to be, since Mr. Mawad is taking mine.
Very good.
I'll buy you a couple. Oops, I was gonna say, I'll buy him a couple cigars and I'll bring his coffee next time I see him in the courthouse in the morning.
Ring size 50 or larger, please.
All right, well, now that that's settled, February 16th, Mr. Brooks. That will also be the date for our next regular review and permanency planning hearing for this child.
Time?
1:30 p.m.
I'll be here.
For purposes of Mr. Mawad's client, Ms. Bailey, that will be January 29th at 2:00 p.m. We'll have 2.5 hours that day, Mr. Mawad. Do you think that would be sufficient?
You know, Judge, I haven't decided yet. Grandma wants to be a witness and maybe 2 other people. I've got to narrow it down because this thing has got to be heard and be adjudicated. So I'm hoping so. They would not be very long witnesses. It's just regarding Bailey's history and characteristics, but I'll do everything I can to get it done that day.
All right, and if we need to schedule more time, then so be it.
Okay.
We'll figure that out. We'll cross that bridge when we come to it.
Okay.
All right, as it relates to any other final comments, Ms. Thomas?
I have none, thank you, Your Honor.
Mr. Mawad?
None, Judge.
Mr. Brooks?
No, Your Honor.
Ms. Berger?
I have nothing additional, Judge.
Well, the court finds all parties were given notice for purposes of today's review hearing, and that the reasonable efforts towards the goal of adoption, which was set at our last hearing, are being pursued. I would hope that, we didn't hear a specific update on licensing, but if that's something that you could look into for us, Ms. Young, in the name of pursuing the goal of adoption, I'd like to know if the placement is licensed or is in the process of securing licensing, and if so, at what stage they are at that process.
Your Honor, I can answer that for you. They are a licensed foster home.
Thank you. All right, very good. Maybe just a note about that at the next juncture would be useful. And as always, your continued vigilance on whether or not either of the parents are accomplishing progress on the now secondary goal of reunification. And I'll look for a brief court report on those issues as it relates to Ms. Demansky on January 29th in preparation for that trial. And then our full report on February 16th, or any updates, I should say, about the father's progress. And as our termination trial proceedings will be about him on the 16th at 1:30 p.m. in addition to the regular review and permanency planning hearing. Are there any questions about that, Ms. Young?
No.
Thank you. All right, the child is in the safest and least restrictive environment that's available to him at this time. He is placed with, I believe, his maternal grandparents, who are relatives, and are taking care of him. He is well there. His father has not been in any communication with really the department in any significant way. This court still, frankly, has a lot of concerns about his abrupt absences and lapses in judgment and his understanding of those. I know we had at our last review hearing information substantiating that he was involved in a drunk driving car accident, which he had denied at the court hearing before that. But I'm also aware that your client has had head injuries. So we have a psychological evaluation, but we don't really have any neuropsych information on him. Ms. Young, if there is anything out there about that, I'd love to read up on it to find out if that contributes at all in any way to some of the behavior that we've seen over the course of the period of time that this child has been under the jurisdiction of the court and the supervision of the department. But I have those concerns as it relates to returning the child to his care. His disconnect from his relatives also is a concern that could have potentially afforded him additional supports in that way. So for those reasons, I do find it's a risk of harm to return the child to his father, who's absent, and his mother, of course, who's incarcerated. So he will remain in his placement pending our further proceedings, which again will be January 29th for the mother's trial on the termination petition, and then the 16th of February for review, permanency planning, and termination trial proceedings as it relates to Mr. Schmidt. It would appear that our jail has entered the waiting room finally. So Mr. Mawad, if you'd like, I'm happy to set you up with a breakout room to talk with your client to give her the updates.
Yeah, I'll do that real quick. That's not a problem. Thank you.
Great. All right, counselors, unless there's any other questions, that's all for today.
Okay, and the next one is the father's hearing. And we will get to see him, get to meet the lovely man. And a lot of good arguments are raised as far as, you know, the concerns for him having, you know, permanent placement of the child. So it's interesting.
0545. Well, first I want to just thank the attorneys for our bench conference.
Oh, actually, I might be wrong. It might be next. It might be after this one. This one might be just like 3 minutes though.
Really enjoy the opportunity to talk with them about a few aspects of the case that many of which we've already discussed today. But I believe, I think we're going to end up with an adjournment to allow a second psychological evaluation. And I'll let them go ahead with any other comments that they might have on the sidebar, beginning with our guardian ad litem.
Yes, thank you, Your Honor. I do believe that we are requesting some additional time to have another evaluation done for mom and to explore other avenues of permanency for this child. So I do believe that we are asking for this day to be reset. We are out of time for the day as well. So before we can finish, I'm asking that we get another date and some more time to explore all the options.
Ms. Thomas?
I concur with LJ on this matter.
I concur.
All right, very good. Well, our next regular review is set for February 16th, so I think that's probably a bit soon. So we'll, I think, let that one go on as scheduled and then look for some time in March. Does that give you enough time to secure the psychological, or do you want a full 90 days?
Yeah, I think I hate the idea of having to extend this out another 3 months, but given, honestly, the last time we tried to schedule one, we were scheduling a month out. And by the time it's completed and then written, I don't know that we'll have it by early March. So,
Yep, that's what I was asking.
yeah. Do you have any idea where we're at this?
Well, if we do that, we are looking at, we can come back together on Monday, the 8th or Tuesday, the 9th of April.
Tuesday the 9th.
Yes, so that would be a 3:30 spot.
Okay.
Your Honor, I don't mind doing that. I just will be appearing via Zoom.
Option B is go to the 23rd.
of April.
Yes, if you'd like to do the first one.
I don't mind being on Zoom if no one else, Matt, if everyone's okay with that.
I don't care. I mean, whichever, 9th, 23rd, it gives us some time now to see what the report reveals and maybe talk more.
Well, let's go ahead and schedule it for the 23rd. Is there, right now you have open on the 22nd and the 23rd. Is there any preference?
I would prefer afternoon if that's okay.
I'm not available the 22nd, but I am anytime.
All right. 1:30, April 23rd.
Sure.
All right, so what we're going to do is leave the proofs open then and essentially conclude with another review and any additional argument will take place on that April 23rd date at 1:30. We will be asking the department to make that referral, and then it will be up to Mr. Mawad to secure permission and logistics around that opportunity.
I'll get on it, Judge. Thank you.
All right, it would appear that all other prior court orders would remain in full force and effect, and that would be the most appropriate. Anything else then for the record?
Nothing further.
Nothing further.
All right, thanks again. We'll see you back April 23rd at 1:30.
I'll be in touch with you daily, okay?
Now for
All
Dad.
right, we are scheduled today for a review, permanency planning hearing, and a hearing on a petition for request of termination of parental rights of Aaron Schmidt as to the minor child concerned in this case. May I have the names of our participants, please?
Good morning, I'm sorry, good afternoon, Ariel Berger here on behalf of the minor children as guardian ad litem.
Ms. Tasha Thomas, counsel for the department.
Caitlin Young, Department of Health and Human Services.
Michael Brooks, I represent Aaron Schmidt. Is Mr. Schmidt in the courtroom or online?
Have Aaron logged in. I don't see anybody else in the courtroom, but we do have an Aaron logged in.
Yes, Aaron Schmidt, representing Braden Schmidt. This is the father.
Thank you. All right, I should say for the record, we did have a sidebar before we came on record today. Any comments on that, Ms. Berger?
I don't think so, Your Honor. We had discussed possibly adjourning this to be held with mother's trial, but I don't believe that that is necessary at this time, so we're asking to move forward today.
Ms. Thomas, any comments?
I agree with LJL, thank you.
Mr. Brooks?
I guess I'm the odd man out. I don't agree. I think it's unusual to look at a termination of parental rights for one parent, not for the other, unless there's some really strange circumstances going on. So my opinion is we should adjourn this until decisions made with respect to where the department wants to go with the mother.
I would note for the record that the termination petition does indicate a request for termination of parental rights for mother and father. I'm not sure if that's been scheduled. I think it has been actually. 4/23/24 at 1:30 is when that one is scheduled. There was one issue that came up. There's a request for a second psychiatric or psychological evaluation in that one in an attempt to measure the benefits from the services that she did undertake. So just to clarify, there is a pending termination request filed for both parents.
Well, I don't think April 23rd, if that was the date, is very far off anyway. So I don't see any harm. The child, as I understand it, is living with my client's parents and has for quite some time. I don't see any immediate problem leaving status quo as it is.
Your position on the request, on the motion to adjourn, Ms. Thomas?
Your Honor, I in part agree with Mr. Brooks that often we look at the permanency for the child, and termination is not permanency for the child. Adoption would be permanency for the child. Part of the issue with mom's case and asking for that second psychological evaluation is to determine whether this child could be reunified with the mother upon her release from incarceration. But as far as the department's concerned, we have put on our proofs in that hearing and are waiting for another psychological evaluation. This petition has been outstanding on both parents since September. Maybe not September. November, I'm sorry. So it's been more than 3 months, and we're well over our standard timeframe, which I think we're supposed to have these within 42 days of being filed. So I would ask that we continue on the termination petition, and if not, then at least get the review portion done.
Your position, Ms. Berger?
Yes, Your Honor. I would request that we move forward with the termination today. They were scheduled at separate times due to availability of the attorneys, not for any other reason. So normally we would have started fathers at the last time we were here when we started mothers. However, we weren't able to schedule it that way. So this child has been in care for almost his entire life. And I think that he deserves permanency as soon as possible. And I think we need to move towards that goal now as quickly as we can. And we have the docket time today, so I would suggest that we continue on with that termination trial today.
Thank you. I can appreciate your point, Mr. Brooks, but the docket for the next couple of months is extremely tight, number one. And number two, I think we're gonna need the time that's been scheduled for Ms. Demansky's trial in April. I'm not convinced that we'd be able to get through both of them in a singular afternoon, which was one of the reasons they were scheduled separately. And the petition has been pending since November 3rd, 2023. And I think it is in the interest of this child to begin to answer the question on permanency and stability. So for those reasons, I am going to deny the motion to adjourn. And we will have the termination proofs in conjunction with the review hearing that's been previously scheduled for this afternoon. Any other preliminary issues?
No, Your Honor.
No, Your Honor. Nothing further, thank you. All right, Ms. Berger, I look forward to your report.
Yes, thank you, Your Honor. I've been able to visit with the minor child virtually during this reporting period, in person, I believe in November or December as well. And I've been in pretty constant contact with his caregivers. He is super tall for his age. I think he's in maybe the 97th percentile for height and weight. He is growing like a weed. His speech is coming along. He's finally fully transitioned into a toddler bed. He really enjoys water activities. So playing in the sink, playing in the tub, taking a bath, all of those fun things. He really enjoys those. But he's very bonded to these caregivers, and I think he sees them as his parents. He's been placed with them since an infant, and they've been the ones providing medical care, transportation back and forth with daycare. And he unfortunately is prone to being sick. He has struggles with that, I think, a lot with being in daycare, but I think he was just sick again a couple of days ago. So that's kind of an ongoing battle that he faces. But they have the ability to stay home with him if they need to, or to go pick him up from daycare, and flexibility in the schedule with it, which I think is important. He's not seen either of his parents in quite some time. Father at one point was really doing well. He was completing services, he was engaged, he was visiting, and then all of a sudden he kind of dropped off the face of the earth and we didn't hear from him. And since then, the child has adjusted to his normal schedule being with his caregivers. He hasn't seen dad. Dad has not provided any support that I'm aware of. So at this time, I'm asking that we move towards permanency for him and that the court enter the orders for termination.
Thank you. Testimony, Ms. Thomas.
Yes, Your Honor. Ms. Young can be sworn in.
Ms. Yan, come on up for a witness stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, yes.
Your full name, please.
Caitlin Young.
Thank you.
Ms. Young, how are you familiar with this matter?
I have been the foster care worker for this past year. So I've been working with this family for quite some time.
And today is in part of the hearing is inclusive of the review portion. Did you provide a court report for today's hearing?
I did, yes.
Okay. And in addition to the court report, are there any other documents that were circulated since your submission of the court report?
Yes, I did send out an email yesterday once I received the therapy information for Mr. Schmidt. So I sent the proof of service and that to everybody. And then today, right before I was coming over to court, Mr. Schmidt sent me a text with his signature on the case service plan. So I do have copies of that for everybody as well, including the courts.
Okay. Judge, may I ask the court and counsel if they have received the court report, the case service plan, and the counseling records?
Well, Your Honor, I have the case service plan, but it isn't signed by my client, so I will have to simply ask him if he signed it and sent it back.
That's the same one I believe I have, as well as the counseling records and the court report. Did you receive the counseling records, Mr. Brooks?
I did.
Okay.
Your Honor, if the court would be willing to receive a copy of the signature portion of the case service plan?
Well, Deputy Ames, would you swear in Mr. Schmidt for us just briefly so that Mr. Brooks could verify that, please? He's online.
Thank you. Mr. Schmidt, can you raise your right hand, sir, and let me know it's raised? Thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir.
All right, Mr. Brooks, go ahead.
Sir, have you heard the witness say that she today received a signed copy of your case service plan signed by you? Did you hear her say that?
Yes.
is an inaccurate statement.
Yes, that is true.
All right. I have no further questions and I have no objection to its entry.
Any questions for Mr. Schmidt, counselors?
No.
No. All right, thank you. And I will receive that. Thank you. Okay.
Thank you. Ms. Young, are there any updates or modifications that need to be made to those documents to the best of your knowledge?
Just at this time, I did confirm with the therapy agency prior to coming over here, because I noted on the therapy reports that they sent me was just simply the dates of when he was seen by Mr. Webb. And then there was some notes from 2021 that was included in there, but there was no like formal diagnosis or like treatment diagnosis that they were working under. So I was able to discuss with them briefly kind of what he was being seen for. So, but it's consistent with some of his other treatment that he was receiving in prior therapy. So it was an adjusted mood disorder with depression. So that was simply what they were seeing him for up through November of this year.
Okay. And have there been any other, to the best of your knowledge, any other counseling since November?
To the best of my knowledge, no.
Okay. And so during this last review period, how would you describe Mr. Schmidt's compliance and benefit from his case service plan?
At this time, just in partial compliance. So, you know, we've had consistent communication, we've been in contact. Because of scheduling, we weren't able to do a whole lot of face-to-face contact, but we were trying to at least meet by phone or text. I've been able to send emails to him with the documents. But as far as the therapy, I am kind of concerned that he scheduled something in December and then didn't go. And there's been nothing since that November, I think either 13th or 16th, I believe is what it stated in the report. He hasn't been seen since then. So I don't know about discussing that with Mr. Schmidt as to why he wasn't completing that, but there's been nothing further beyond that. There's been no other services that he's participated, to my knowledge.
It looks like reviewing the report that you provided, the last date he was seen, and based on this, it looks like December 7th, 2023. Does that seem about right?
That was a scheduled one, but he was not in attendance at that hearing. It notes on in the front of the document that a booked appointment means the appointment was made, but could not have been a no-show, and checked out means he had an appointment and that he was seen. So,
Okay. So that was the last scheduled one, and that's what you're referring to, he did not
yes.
show.
Okay, correct.
And to the best of your knowledge, has he provided any documentation to you that he's engaged in therapy elsewhere?
No.
As it relates to like the psychological, neuropsychological evaluation, he completed that in August of 2022. Do you know if he's completed any of the recommendations?
One of the recommendations was him to follow through with the counseling, but he's been very inconsistent throughout this entire case and consistently staying with one therapist. At one point, he was seeing Crystal Strickland out of Monroe County, and he was going there very briefly, and then that's when we were looking at potential reunification. He stopped visiting, he stopped communicating for a few months, and then just re-engaged in services around June, July of 2023. And that's when he enrolled in therapy with ACPC for Adrian Counseling through telehealth. He was being seen up until about November, and then there's been no further appointments since then.
As relates to his housing, in the past, it's been appropriate. Does it remain appropriate at this time?
As far as, to the best of my knowledge, yes, he's still remaining in the same residence that I last seen him at. He's out in Albion. So.
And has he provided proof of income?
Nothing recent, but we have discussed that previously, that he was still remaining at that same company. I don't have anything recent this reporting period from him showing continued proof of that income.
One of the comments that Ms. Berger made in her report indicated Mr. Schmidt has not provided for the child. Do you have any information on that point? Has he given the placement, like any financial resources or any material resources for the child?
To my knowledge, no, nothing recent. He does not have direct communication with his parents who have placement. We've just discussed that quite a bit over the last like 6 months. He feels very like, hard to explain. He's kind of hurt. He's very distraught with some of the things that happened early on in the year. There was a lot of things that were said in a family team meeting. He kind of withdrew from wanting to participate and then trying to re-engage. And at that point, he was trying to make some lifestyle changes. He moved to a different area and with his now fiance. And he wants to remain, that communication strictly through the agency at this time. So
When is the last time that Mr. Schmidt saw his child?
I believe the last scheduled visit was March 20th of 2023. I think that was the last one that he participated in.
And that's 11 months ago. Has he asked what he needs to do to reinstate visits at all?
We've discussed that. We actually had a meeting with his attorney to try to discuss seeing if he could request to do supervised contact and what that would look like. We also talked about engaging in therapy services and then exploring any other possible resources in his community that he felt that would be beneficial to him. At that time, he was already engaged in therapy services. He was still kind of in denial as to the situation that brought the child into care, that he had any involvement in it. He didn't feel that it was fair to him, that he was not being able to see his child or to be able to have him back in his care. So there was a lot of emotion expressed by him. And myself and Mr. Brooks at that time during that meeting were trying to explain to him these were some of the things that occurred. For that time period, there was no communication from him. You stopped visiting. We were ready to reunify with you. We had services put in place. You refused to cooperate with those services. And then you disengaged from everybody and everything related to this case. So, we had that long discussion, and since then, we've talked about continuing with therapy services, trying to maintain that. We understand visitation is suspended. We can't do anything about that. Alternative means to be able to communicate either through the agency, written contact, what can we do to try to at least have some sort of involvement in your son's life. But there hasn't been any written communication at all from Mr. Schmidt for his child.
And just for the record, when did you and Mr. Brooks have that conversation with Mr. Schmidt?
I don't know the exact date. I believe it was around November of 2023. It was a phone call. We did a meeting over the phone, three-way call to discuss some of that.
As it relates to parenting education, though, he did complete some of those services during this case, correct?
He did. Prior to me coming onto the case, he had just finished up a program through Orchards. And I believe it was about a 6-month, pretty in-depth parenting education program. Once he completed that, that was at that point we were looking at FRP services to reunify. It was just a matter of basically switching programs to their organization, but there was no communication or very little communication between him and the workers. They would set up dates to work with him, and he wouldn't be there, or he wouldn't communicate, hey, I have something came up, I'm not going to be home. So they would show up, and it would be a no call, no show, unfortunately. But so he has completed some. Is there benefit? I can't say yes or no because, with the inconsistency since completing that program, it's really hard to say what kind of benefit that he did show from that.
And you guys heard it. Every hearing up until this point, all of Bailey's hearings, Mr. Schmidt, the attorney had almost no contact with him. In fact, in not the last one, but the one before that, the attorney had to very openly on the record say, this comment is for my client. You either step up or they're going to start termination proceedings. So all of a sudden, I don't know if the check cleared or what, but now the attorney is all kinds of, you can't do this to my client. My client's the father, and he should have, the opportunity, the chance, and this is uncharacteristic to seek parental rights termination separate from the mother and all that other stuff. It just, come on. The guy abandoned his child. He just abandoned him. The kid deserves better and has better right now with his parents. And, to that end, his parents, he's the one choosing not to have any relationship with his parents because he's upset about, them taking custody of the child and him, not having it. So rather than fight for his child, he just walks away again. And if he were to suck it up and, work the program and swallow his pride, he could be having a relationship with his child right now because they're with his parents. But he's a big baby about it. Definitely should not be raising that boy, in my opinion. And maybe part of it is the traumatic brain injury. I understand that's got to play a role in it. But nonetheless, that shows that maybe he's just not the right person for the job. But he now has a new family with a new fiance. Oh. Let's just hope that he stops bringing children into the world until he is ready to care for them. Okay, I hit the button. There we go. Okay, it's not frozen.
At this time, do you think that there would be a substantial risk of harm to the child's life or mental well-being if the court were to reunify the child with Mr. Schmidt today?
At this time, yes.
And can you just briefly elaborate what that risk of harm would be?
At this time, because he has not had a consistent contact with his child since, for about 11 months. This child is not familiar with that structure no longer. Like, he doesn't have that parenting time with him on a weekly basis. He's not able to familiarize himself with Mr. Schmidt. So at this time, it would be a matter of he would need to be reintegrated with him in a supervised setting moving forward, if that were to be the case. The child has been in care, as Ms. Berger had stated, almost his entire life. And we are here almost a little over 2 years into this case, and this child has not seen his dad for 11 months of that time. So
11 months of the kid's 2.5 years on this earth.
This time it would be a risk of harm to return him.
The conditions that brought the child into care came from a half sibling of this child being physically abused, but Mr. Schmidt was not the alleged abuser in that case, correct?
He was a household member, but not the perpetrator, from my understanding. He was not the one who inflicted the injuries.
And so part of the concern was, I guess, his parenting ability. Is that correct?
Yes.
And you stated that when you had this conversation regarding parenting time or what can happen to get that reinstated, he still isn't understanding his role in that. Is that accurate?
That is accurate, yes.
Okay. As relates to the barriers to reunification, are there any other barriers that are in place other than the lack of bond, and sort of maybe this lack of insight as to why the child is in care?
A lot of it is inconsistency in his services. So the inconsistency in addressing the outlined concerns that was in the psychological, the inconsistency not only with not being able to have contact, he, for a time frame, he wouldn't even communicate with the agency. So there was a lot of concerns with his ability to be able to effectively communicate, his ability to be functioning through high stress situations. I mean, that was a very stressful time, and he disengaged. So this time, some of those barriers really fall along the lines of the outlined concerns in that psychological, with the depression, the anxiety, and social withdrawing, which is all very consistent in his lack of participation in the various services and continued attempts to be reunified.
One of the indications, or one of the notes in the psychological evaluation by Dr. Hagen indicates that Mr. Schmidt is at risk for further child abuse and neglectful tendencies, but that could be potentially due to a TBI dating back to 2014. Do you know if he's engaged in any services to address the TBI and how to, I guess, manage life while suffering from a traumatic brain injury?
Reading back into it and kind of taking a look at when that happened, because that happened about 10 years ago, he did seek treatment. It was inpatient treatment, from my understanding. It was very intensive, and it helped to essentially retrain his brain so that way he would be able to function in more of these like high stressor situations, and be able to really be really independent and everything back in the community, because it was, a traumatic brain injury. So with that, his impulse control was affected. His ability really to be an effective parent full time was highly effective, and showing in his inconsistency in all of these areas, with his service providers, with the communication with the department, with communication with the courts, his parents, and so forth. He also doesn't have, from my understanding, little to no contact with his other children, with his first wife, one of which was the child that was sustained the injuries. So, there's been a lot of the impulse decisions. He up and left his place here in this county and moved to another county with someone who he was just learning to get to know. He's now since engaged. We were just informed today before the hearing too, that he also has another child on the way. So, there's a lot of concerns, a lot of barriers, a lot of inconsistencies with that falls along the lines that stems from, we believe, from this traumatic brain injury.
I missed that in editing. He has a child on the way with his new fiance. Oh, dear Lord. Oh, dear Lord.
In part of my question, we moved to best interest factors for the child. I think it's been stated a few times today that this child has been in care for nearly his entire life. Is that accurate?
That is accurate, yes.
Child's now 2.5.
He will be 3 in March.
Okay. Maybe we have his birthday wrong on here then.
Let me double check.
Yeah, he didn't perpetrate the act on the child that was injured. He didn't physically do that. However, the injuries were not reported. He had to have come home from work. From the sounds of it, there was very visible, obvious showings of the injury. I guess the knot was like very, very large on a very small head. And he had to have not seen that. He had to have ignored all signs of, you know, how the child was acting and responding. And it wasn't seen until the child was in daycare or school the next day. And then it was reported to the biological mother. So, and of course, law enforcement at that point. So no, he didn't commit the acts, but he also did absolutely nothing to help his child after the acts were committed upon him. And as we heard in the original case that we watched, you know, when she had a panic attack, he punished the kid that she had a panic attack. So, no, he didn't do it. But he also didn't help once it was done.
So I thought I had it right. Apologies, I do not have his date of birth right on here. But okay. But he would be turning 3 this year.
Okay. So he was removed, if his birth date's in August, he was removed when he was about 6 months old.
Correct.
Okay. And since then, he's been in one home since that removal, correct?
That is correct.
And out of the last 2 years, he hasn't seen Mr. Schmidt in one.
Approximately.
How would you describe that bond between the child and Mr. Schmidt?
Currently, I mean, I don't believe that there would be an effective bond. He hasn't seen him in 11 months. I mean, I think prior to not seeing him, I think their bond was, you know, he had a good bond with him. He was doing unsupervised visits. He had, you know, that decent time with Mr. Schmidt. They had a good relationship with placement. And then once that contact severed, I mean, he has not seen or heard or had any involvement with his son. So there, at this time, there wouldn't be that parent-child bond that we'd be assessing.
Since the child has been in care, has all of his needs been met?
They have, yes.
And has this child thrived with stability since not having parenting time with his parents?
He has been thriving where he's at.
Prior to that, and I don't know if you're the caseworker then, but when he was having parenting time with his parents, were there any concerns about his behaviors after or before parenting time?
Not that I can recall. There was a couple of months after I took over the case where there were still consistent parenting times. I don't recall really any negative behaviors that the child was exhibiting.
Okay. Does the foster, or I'm sorry, the relative placement, do they support sibling visits with the child? The child has half siblings from both mom and dad, correct?
Yes.
And do they offer support in trying to engage with those other siblings?
They do, yes.
And will the current relative placements provide permanency through adoption if this child's ever freed for adoption?
Yes, they would.
And one of the things the court must consider is that the fact that this is a relative placement and this is a paternal relative placement. And do you have an opinion as to why that does not weigh against termination in this case?
Well, at this time, I mean, in speaking with a relative, their wishes are to be able to adopt, to be able to provide that permanency and stability that they would not necessarily be able to provide to him in any other permanency plan. He's still pretty young to do like a guardianship. If they were to reunify, I mean, it would be a significant amount of time before reunification would even be able to be considered due to the lapse in time that the child has not been able to engage in any parenting time with either parent. So at this time, my opinion would be that he would need to have that permanency, and with him being in care for almost his entire life, this is the only home that he's really known and he's used to and bonded with.
And even though this is the paternal relative, earlier in testimony, you stated that there's right now not a good relationship between Mr. Schmidt and his parents, correct?
That is correct.
And they're not communicating.
To the best of my knowledge, no, they're not in any communication.
So Mr. Schmidt doesn't have the opportunity or doesn't take advantage of any of these special arrangements that could exist, such as coming over for Sunday dinners, celebrating holidays together, any of those things?
No, not at this time.
Okay. Is there anything else that you'd like the court to know or consider today as it makes its findings for the review hearing, permanency planning, or for the termination?
I think just a couple of things that I've noted from my home visits with the minor child. I've had some discussion with the placement about some different situations that they've been in with the minor child. There was one incident where, I mean, as Ms. Berger stated, he loves water. He had finished dinner, got in the bath, getting ready for bed, and he ended up choking on water. And it was a very stressful, high intense situation where paramedics had to be called in. CPR was being done because he wasn't breathing. So, you know, it's hard to say like how either of the parents would handle that situation. The parents, the grandparents, in speaking to them, I mean, they worked together as a team. They were able to, you know, one was on the phone with paramedics to make sure that, you know, they were doing the proper steps as far as the CPR. The other parent, grandparent was in there performing the CPR, making sure that his airway was being cleared and he was back breathing, making sure that he was all right. And then there was another incident shortly after that where he was down for a nap, I believe. And with him being in his toddler bed, he has a little bit more free reign in his room. He had woken up, had soiled his diaper, feces, and spread it everywhere. You know, so another, you know, highly stressful situation where there was literally feces all over the room, including all up and down his arms, his body. Thankfully, you know, the bathroom is right next to his bedroom, so they're able to, you know, put him right in the bathtub, get him cleaned up. But again, like I said, this is another very stressful situation. It's hard to say how Mr. Schmidt or Ms. Demansky would have handled that. You know, with it being as severe as either one of those things were. I mean, there was a lot of cleaning up, a lot of, you know, scrubbing carpets, cleaning up the beds, the walls, the blankets, the pillows, stuffed animals, everything, you know, everything needed to be done as quickly as possible because of the smell. You know, so it's really hard to say how either one of them would have handled that situation, especially with that being that highly stressful situation. So, but I like I said, I did commend the foster parents and how they handled that. They, you know, they were a very good team, working together in handling not just that, but also other like really good situations with this child. And, you know, he's very loved, he's very cared for. He doesn't have a need that goes unmet by far. They are a licensed foster parent, so they are aware of the protocol with, you know, any type of discipline, you know, how to maintain their home as far as licensing standards. So, you know, they're very well equipped to handling these situations. And have a very good support through not only our agency, but also the agency that they're licensed through. At one point, they did have a very good line of communication with Mr. Schmidt. And then at one point, they, you know, following a meeting and some allegations, it just, that line of communication was severed at that point. So, you know, at this time, you know, we asked that we can move forward and continue with this process towards adoption.
Thank you. I have no further questions. No to admit the court report with the attachments. Thank you.
Objections, Mr. Brooks? Oh, you'll have to unmute, sorry.
No, Your Honor. No
Okay.
objection.
Thank you. The court report and the medical records are received, as well as the case services plan. Questions for this witness, Mr. Brooks?
You mentioned that, let me find it here. He doesn't understand his role in the abuse of this child. Was that your testimony?
I think there is some question in his ability to understand that. I mean, there's times where he gets very frustrated and doesn't understand as to why the child was brought into care or why he's not able to have the child in his care. So yes, there is some question as far as his ability to understand the severity of why we are here today.
but he really didn't have any role in the incident, did he?
I couldn't say for sure. I mean, there was some inconsistency as to that CPS investigation when they were interviewing both parties, and then the minor children that were able to have an assessment. So I don't know if he necessarily was a part of physically abusing that minor child, but he has a role as a household member, an adult, a parent to that minor child that was injured.
Well, at the time it occurred, isn't it, according to police reports, he was at work, wasn't he?
From my understanding, yes. I think the follow-up, following when he got home from work and, you know, when the child was observed at school the next day, there was some question as to why, you know, he was not observing that child himself before that child went to school. So there is some question in regards to that. And so I think he has a role in it, but not to the extent mom did.
Okay. When is the last time he had contact with his son?
March 20th of 2023 was the last scheduled parenting time that he had with the minor child.
And we're here on March 16th, 2024, right?
February.
Oh, I'm sorry, February 16th. So 11 months.
Correct.
And his father was a strong supporter of his early on in this case, was he not?
His stepdad and mom, they were very supportive,
His
and they have
stepdad.
been this entire time. But I'm that middle person in the communication between Mr. Schmidt and his parents at this time.
So something has changed in that relationship, right?
Correct.
Do you know what?
Well, we had a family team meeting a while back, I want to say it was around that March 20th timeframe. While we were in that family team meeting, I mean, there was a lot of concerns that were expressed by not only our agency, but also his parents, some things that, you know, really fall under the lines of concerns being unsupervised with a minor child. There were some reports that he was being around some individuals who were not really safe for not only Aaron to be around, but also the minor child to be around. So there were some safety factors, and we had police reports that supported that, that safety factor. There were also, you know, and I don't know exactly what else was said between them following that meeting, but I know there was just, you know, a lot of emotions kind of that followed that. I mean, Mr. Schmidt didn't really agree with everything that was being said, and he just felt like he was being attacked and that he wasn't being supported in that moment. We were trying to be as supportive as we could, trying to kind of get to the bottom of what the concerns were. And at that point, we were recommending to try to do some supervised visits again. So that way we can look into things further. You know, if there were continued safety factors, we wanted to address that and make sure, you know, the minor child was not put into an unsafe situation in an unsupervised setting. So, you know, we're taking a look at it, covering all grounds at that point.
Now, you've indicated that basically he has been a no-show for the better part of a year. Is that an accurate summary of what you said?
Not necessarily a no-show for everything. He has had a lot of inconsistencies. I wouldn't say necessarily a no-show. There were some inconsistency as far as his therapies previous to where he's at now, where they would have, you know, some sessions sporadically and then, you know, no communication for a significant amount of time, where he then was discharged from that service.
Well, counselor, you indicated that he was a no-show at all of the previous hearings. So just pointing that out.
The same thing was for FRP back early of this last year. He would set up appointments and then he wouldn't be there for those set appointments. So, you know, again, that inconsistency of any form of communication, and then, you know, he just stopped communicating with anybody for about 2 months approximately. So when he started therapy back up, he was consistent for a short time, missed, and I don't know the extent of why a visit or the therapy session was canceled, but then he had a few more sessions and then no more since then. So, I mean, there is concern with that inconsistency, yes.
Where does he live? And I don't mean the address, but what town?
He's currently in Albion, Michigan, from my understanding.
Albion. Has he expressed to you any issues with transportation to get to his various and sundry programs?
No, his therapy sessions are telehealth, so it's all virtual. It's not a face-to-face session.
Do you know if he has a computer or a phone that would allow him to take advantage of that?
Yes,
He does have that.
he does, yes.
When did the court suspend all visitation with the boy and his father? Do you
I
recall?
think a motion was filed around, I think, May 26th or 27th of 2023.
So from essentially June 1st on, he's been prohibited to visit with his son. Is that right?
That's correct, yes.
So for 6 or 7 of those 11 months, he's just flat out not been allowed to see his child. Is that right?
Per a motion, yes, but we discussed steps that he could take to show that he wanted to be involved in his child's life. And he tried to do some therapy sessions, but that was the extent of his participation in anything in regards to that reunification process.
I have no further questions. Thank you.
Ms. Berger, any questions? No, Your Honor. Thank you.
How did that help his client any? Like, she had the facts for, all of his questions, and everything just made his client look worse. Does he have a phone that can do the virtual appointments? Yes. Oh, he does? You sure of that? Yes. Oh. Well, isn't like one of the main rules of being an attorney, you don't ask anything you don't know the answer to? Or was he just hoping she'd say, I'm not sure?
For your testimony? Well, maybe I should check with Ms. Thomas and redirect.
I have none, thank you.
All right, thank you for your testimony. We return your seat. Other witness testimony today, Ms. Thomas?
No, Your Honor.
Mr. Brooks?
Mr. Schmidt, would you like to testify?
No.
Pardon me?
Yeah.
Okay. You have to be sworn in.
It's already been sworn in.
Oh,
Yes.
that's right.
That's it. Mr. Schmidt, you've already been sworn. I'll just remind you, you remain under oath.
Okay.
You've heard the testimony of the worker, Caitlin Young, have you not?
Yes.
All right. Is there anything she said you disagree with?
I disagree for the fact that I have been trying to find ways to move forward into my absence. When I left flat I left flat from the earth or disappeared for the months, and I've been asking questions to the case service, Caitlin. What do I do? What are my steps?
Okay, you're really cutting in and out. I'm not getting maybe even every other word on this end. So
I'm sorry.
I'm not sure. Maybe you could try to move in closer to the microphone and try again.
Okay, is this better?
It is, yeah.
Sorry about that. So when I disappeared in those few months, and then I tried to come back and move forward, I have tried to and been engaged more by asking Caitlin, my case service worker, what do I need to do to move forward in this, and to do better for Braden, to show that I am more motivated for Braden, and to just do the best that I can for him. And at the time, the only thing I had to complete was my counseling, so I've been doing that ever since. trying to show more effort to showing um, what I need to engage in since then.
What is the counseling you've been engaged in?
So his name is Nate Webb, and we talk about my emotions and how to handle them. Talking about how things are going in life, how I'm handling my situation with Braden, where do I need to go and get him back, and talk about everything.
How often do you see this counselor?
About once a week, once a month.
One big difference between once a week and once a month. Which is it?
So it's normally once a week, and then he had getting married this month, so we waited out. But it's normally once a week. The normal is once a week.
And how often or how long has that been going on?
It's been going on since November.
Of 23?
Yes, sir.
Is he someone local over where you live, or is he on online counseling?
He's from Adrian, but we do online telegraph.
Okay. Are there any other things that you're doing to benefit yourself in this matter?
Just
Well, let me help you out. Are you working?
yes.
Where do you work?
So I work at Denzel Manufacturing. I've been there for almost a year.
All right. What are your hours there?
I work about 70 hours a week.
70?
Yep.
Wow. Okay. Have you contributed anything financially for your son's care?
I have not.
Can you tell us why?
I have not been able to engage with him.
Well, he's only 3, right?
Yes, sir.
Have you been able to engage with his caregivers? I understand that is your mother and her husband. Is that right?
Yes, sir. And we have not engaged or talked.
What's the problem?
Just have some personal issues with them. I just didn't agree with. So we just moved forward and haven't talked to him since because
He caught himself there. He almost went into victimhood territory, and he was about to say that they're very manipulative. I think he realized, I think he just had that momentary, I better not, because they have my kid. And so either that was preservation of his child, or that was preservation of self. Because if he had gone into the, I'm a victim spiel, that would have ended terribly for him.
Well, you do understand that in order to have a relationship presently with your son, you have to go through the DHHS and his caregivers, right?
yes, sir. And I would treat that with respect and just be mature about things and not. If I was ever to have visitation with my son, me and my mom have nothing to do with Braden. With our personal issues, it's all about Braden, take care of him, and getting along with my mom for Braden at that point, or along with my stepdad at that point. My personal issues will not affect with co-parenting or anything personal with Braden.
Okay. Have you made attempts to reintroduce or begin having contact again? Have you tried to get something done about this court order?
Yes, sir.
What have you done?
I've been talking to Caitlin, my case service plan, to see what I need to do to move forward. and move forward into a reunification with my son. And so,
When, I'm sorry, I didn't mean to interrupt. Go ahead.
and so doing these plans was the option at that point.
When's the last time you made an attempt like that?
I want to say when we had that meeting, me and you, to move forward. And ever since, I've been doing my counseling and engaging into my plans as I need to and be more motivated as a father.
Okay. Okay. If there were other things in that case service plan to do, are you willing to do them?
Yes, sir.
Probably on these telehealth programs, right?
Yes, sir.
Are you taking any medications at this point in time?
No, sir.
Are you supposed to be?
No, sir.
They mentioned you have a traumatic brain injury. Are you aware of that?
Yes, sir. That happened when I was 19.
How old are you now?
I'm 29.
10 years ago. Are you aware of what limitations, if any, that injury is causing you?
Yes, sir.
What are they?
My emotions. So I've learned from when I went to rehab for a year in the beginning of my accident, how to control my emotions and how to, all these skills of emotions and how to handle things more properly. And then also, while through these services, also in my parenting classes, they have taught me to find different ways into being more engaged with Braden and being more how to do things more appropriate and be more teach him the skills that he needs to learn through my parenting classes and counseling and looking for guidance. So recognizing when I need to do something for Braden or when he does something bad or seems bad at his age, to understand that, the appropriate of what he knows at his age and knowing how to discipline and knowing how to teach him right and wrong.
Well, you have not personally been involved or even accused of, how would I put this, any inappropriate corporal punishment of your son, have you?
No, sir.
What would you like to see the court do here today?
To move forward and if a possibility to have reunification with my son. I know it's a lot to ask, but I think I owe it to him to show that he still needs a father. And I think that it would be best for him in the long term, to know more of me, to be more comfortable with me, and to just know me.
Is there anything else you'd like to tell the court?
No, sir.
Thank you. I have no further questions.
Cross-examination, Ms. Thomas?
Just a couple of questions. Mr. Schmidt, can you hear me okay?
Yes.
Okay. Mr. Schmidt, you mentioned that you have been in therapy since November with Mr. Webb.
Yes.
The medical reports that we have indicate that therapy started back in July. So
it started in July, and then he had some things going on, and so we had to reschedule. And so I've been attending to my appointments. I went back to November with him after his vacation and stuff like that.
These reports indicate that you had essentially monthly, bi-weekly appointments with him. And then your last one was scheduled for December 7th and you haven't been back. Is that accurate?
That is accurate.
So he's been on vacation for 2 months?
Yes.
In your parenting classes that you just testified about what you learned, Did you learn anything about what it might be like for a 2-3-year-old to not see a parent for a year at a time?
So in my parents' time, my parenting classes, they've taught me to, we've talked about, I've asked questions about, it's been a while since I've seen my other kids. So I would like to know how to get them more comfortable with me, because it's been a while since I've seen them too. And unfortunately, I'm not able to see them until this case is closed. It's been a long and rough process, but we've talked about also in my counseling, how to deal with getting them to be more comfortable in seeing me and to my environment. So I've talked to counselors on how to, and my parenting class teachers on how to properly be reunified with my kids when I see them again, because it's going to be hard. There's going to be a lot of crying. There's going to be a lot of emotions. So to answer your question, yes, I have.
The crying is not, you might be crying out of excitement and joy. The crying from your children is going to be because you're being pulled from the only parent they know. But there's that.
So what might it be like for a 3-year-old to be reintroduced to you who hasn't seen you in a year?
So there's going to be a lot of not being used to me. He's not going to know me. He's not going to see me as his dad. He's going to be more towards my mom, my dad, because that's what he's more comfortable with. But from what I've been taught and for the techniques I've learned, just to let him know that he is safe and secure with me, and just to let him know, like, he can be in a loving, warmth environment here too. Just to let him know, like, things will be okay, and to work with him and be patient with him, and just to keep working towards our relationship or building one.
Do you think it's fair for your child to wait 2 years for you to be ready to parent him?
I don't think it's fair for anybody to go through the time that we've missed and the years that we've missed. So no, I don't think it's fair for anybody.
Okay. I have no further questions, Your Honor.
Ms. Berger? No questions. All right. Anyone else you'd like us to hear from, Mr. Brooks?
No, Your Honor.
Ms. Berger, any witnesses today? Not today. Very well. Argument, Ms. Thomas.
Thank you, Your Honor. As relates to the review hearing, we ask that this court find reasonable efforts towards reunification continue to be made, despite the goal being adoption, but we also ask the court to find reasonable efforts towards adoption were being made during this review period as well. We are not asking for another review period because we are asking this court to determine adoption remains the best permanency goal for this child, and that termination of parental rights is appropriate at this time. Although I did not plead in the petition, I would ask this court to consider termination under statutory grounds of MCL 712A.19B3, subparagraph A2, which is that the parent has deserted the child for 91 or more days and has failed to seek custody of the child. I think that's pretty clear in this case that we've had a father who had disappeared for a while, parenting time was suspended. He did not try to engage in anything to object to that order to suspend parenting time. He didn't avail himself of services. This court has the record from the last 2 years about how inconsistent he has been, and really how this last year derailed that progress. And I think that speaks to subsection C1 or CI, that Mr. Schmidt has been a respondent for more than 182 days. has been responded, and it's been more than 182 days since he was entered into his initial dispositional order, and that the conditions that led to adjudication continue to exist, which were the failure to protect and improper supervision. Again, today we're hearing testimony that he didn't have any, or this idea that he didn't have anything to do with the child's half-brother's physical abuse, but the real condition there was the failure to safely parent. And to this day, we still don't have any proof that he can do that. And actually kind of the status quo that he hasn't, despite being engaged in services early on, hasn't demonstrated any benefit from them in the last year. And that's not the caseworker's fault or anyone else's fault other than the parent who has the responsibility to engage in services and show benefit from them. Given that this child has been in care for 2 years, I don't think it's appropriate to ask this child to wait another year for there to be sufficient compliance with the case service plan to show benefit from it and then to be reintroduced to this individual. I also think that there's clear and convincing evidence under subsection J, the reasonable likelihood based on the conduct or capacity of the child's parent, Mr. Schmidt, that the child would be harmed if returned to him. We heard today how, I guess we were reminded of the inconsistency that Mr. Schmidt has had throughout this case, how this child is thriving with his relative placement. This child has been pretty sickly throughout this case, as we all are aware. In the relative placement, they've done what they've needed to do to safeguard this child and make him healthy. One of the things that we enjoy hearing is how well he's developing, how big he's growing and how fast he's growing. So for those reasons, I believe that there are grounds, at least one ground, under the statute to terminate Mr. Schmidt's parental rights, and also that it is in the child's best interest to do so. This court must find by preponderance of the evidence for the record as a whole that is the case. And I think that this court is very aware of the facts of this case. And I'm not going to belabor the point, other than just to note that although this is a relative placement, the parent has not been able to benefit from that relationship. We've heard that there's been a breakdown in that in the last year. They don't communicate. Mr. Schmidt now claims that he could co-parent with them, but he's had a whole year to attempt to demonstrate that and has failed to do so. This child deserves permanency and stability. Given his young age, he is in a home that is willing to provide him that permanency. It meets his needs. They give him age-appropriate activities. They're able to respond to stressful situations without becoming derailed, without detaching from the world around them. And they encourage that relationship between him and his other half siblings. So I believe for those reasons, it would be in the child's best interest to terminate Mr. Schmidt's parental rights. At this time, I know that there's the question about whether guardianship would be appropriate, given the progress that the mother made in this matter. But that question remains unanswered at this time, as we are still waiting for the proof on that. And despite that, we would ask the court to still move forward with the termination so that this child can experience permanency one way or another and be safeguarded from any further harm that a relationship with Mr. Schmidt might cause. Thank you.
Mr. Brooks?
I find it hard to understand how the DHHS can say that terminating my client's parental rights furthers their cause of creating permanency for this boy, when at the same time, they say they're not at all sure that they're going to try to terminate the parental rights of the mother whose actions brought us to this case initially. And now maybe we still got to decide whether there should be a guardianship there. It's convenient for them to say my client has a role because he should have followed up in a different manner, and maybe they're right. But I think it's a little strong to say he played a role in the abuse of this child. My client has a TBI. Everybody agrees with that, including my client. And I think once the court issued its order, I don't know, in June, I guess, of last year, saying he was prohibited from visiting with his child because he wasn't visiting regularly. I think at that point, I think the DHHS gave up any pretense of making reasonable efforts to reunite this child with his dad.
Your client gave up on his son. End of discussion.
Now, ordinarily, absent the issue of this diagnosis of his brain injury, I would have very little sympathy with the parent. Given whatever the heck is going on in his head, I think some slack should still be given to him to get reacquainted with his son and see if perhaps something can be done to get them back on the same track. Why? Because I don't know what his limitations are. Maybe his limitations are such that he can't. But I think the trigger was pulled on this man pretty darn quick. And I really don't think they have made reasonable, they being the DHHS, has made the reasonable efforts to reunite this man with his son. And I'm still concerned about the fact they say my client played a role in injuring this boy when clearly he didn't. He had no role other than his mental limitations, which I think is a rather strongly phrased idea of what his role in this was. And I think you should allow him. And the other thing is, you may, or the court may or may not, depending on what's advocated by DHHS later down the road, not even terminate the mother. May just grant a guardianship, when in fact it was her behavior which generated this whole thing in the first place. She pled guilty to, I think, second-degree child abuse. Nobody even charged my client with that. Nobody ever accused him of anything like that. Yet they're still considering maybe letting a guardianship be put into place. So I fail to see, one, how there's any, by terminating my client's parental rights, how it can be said that they are advancing the goal of permanency for the boy. They are not. Two, when they say they've used reasonable efforts to re-engage my client, given his limitations, they have not. And for those two reasons, I'm asking the court to deny the motion for termination.
Thank you for your comments. Ms. Berger?
Yes, thank you, Your Honor. I think it's been testified to pretty clearly today that there doesn't exist a bond between this child and his father at this point. It's been almost a year since they've had any communication or any contact, and that's solely the father's choice, decision, and fault. He was thoroughly engaged. He was actively engaged. I think that at one point I might have recommended reunification. We were getting ready to start reunification FRP classes. And at that point, father, for some reason, just kind of dropped off the face of the earth. And I don't think the agency is pulling this case too soon. I think we're almost timed out, actually. This father has had so much time to complete services, and he did complete a lot of services, but he was unable to maintain stability throughout this case. He completed what he needed to complete, got up to the point of reunification, fell through, and then couldn't fully engage again to the level in which he was previously at all for the last year almost. This child is young. He does need stability. He's been enjoying that for the last several months in the sole care of his caregivers. Whether or not mom's rights are terminated, I don't think have any bearing
on if the statutory criteria have been met in this case, and I think they have. I do think that it's in the child's best interest and that it does support termination of this parent's rights. Obviously, this child is quite young and can't express his wishes, but from how he acts and how his behaviors have changed since he hasn't had any visits with any of his parents, I would say that he also is in support of this. There's a very high likelihood that he's adopted. His current placement are licensed foster home already, so we don't even have to wait for licensing to go through. And they facilitate things like extended family visits, sibling visitation. They've been able to arrange birthday parties and all sorts of things where they invite extended family, where they make sure that this child's siblings still get to be involved in his life and he and theirs. So I think that he's in the best place for him. He's being cared for by the best people to do so, and that the petition should be granted.
Thank you. The court finds that all interested parties were given notice for purposes of today's termination hearing. I do find that reasonable efforts towards the goal of adoption have been made with the secondary goal of reunification by our caseworker, as well as Ms. Berger in satisfaction of her obligations. Thank you.
Thank you.
For further purposes of the review, I would note that the secondary goal of the reunification between this child and a parent, there are efforts that were demonstrated towards that secondary goal as well. There was a lot of conversation today about a meeting that was held with Caitlin and Mr. Brooks and Mr. Schmidt in November. And we never nailed down exactly when that happened, but given that the termination petition was November 3rd, 2023, my guess would be that it would be sometime after that if it happened in November. That seemed to be the onus for Mr. Schmidt to re-engage in some counseling services, but by December 3rd, he had abandoned those efforts, as well as any efforts to reconnect really with the department or his child. And those really are the only efforts that we've seen from him since he had a very significant incident happen in February of 2023.
Was the judge paying attention? Oh yeah, she caught everything.
So I cannot find that any efforts were made by, or any real efforts that would result in progress were made by Mr. Schmidt in the areas that constitute high risk in this case in the last review period. And that is very consistent with what we've seen since March of 2023 from Mr. Schmidt. So for purposes of the review, the department has certainly satisfied their obligations, and the permanency planning goal of adoption, it continues to be accurate. Ms. Domansky remains incarcerated. She's not present for purposes of today's review hearing, but it's clear from the court report that nothing has really changed on that front. We just had a very recent review that encompassed looking at her progress as well. So entering the review order from today has no detrimental effect on her case as well. She's going to be in a holding pattern until we get back, the exception of hopefully being able to access that psychological evaluation. So I will issue that review order documenting those pieces. And as I look at that evidence also, or the evidence that came out today and the case as a whole for purposes of termination, I of course have a couple of statutes to evaluate on this point. A termination of parental rights hearing is really, the court has to make findings in two phases. The first is to determine whether there's clear and convincing evidence to support statutory grounds for termination of parental rights. The second is to determine if it is in the child's best interest to terminate those parental rights. The department has asked the court to evaluate the case under 712A.19B3A II, in addition to evaluation under 3CI. And I do find that that's appropriate. I also think that the evaluation under subsection J is also relevant. So I will have it, well, actually also G and J, frankly, all apply in this particular case. And I'll go through those one by one, but I do think that there's clear and convincing evidence in this case that there has been a violation of this statute. to justify termination of the parental rights of Mr. Schmidt. Beginning in order that the statute asks me to look at them, 712A.19B3AII asks the court to determine whether or not this child has been abandoned for a period of 91 days or more. Let me grab the actual language, one moment. Most updated section here. Here we are. Child has been deserted under either of the following circumstances. II indicates the child's parent has deserted the child for 91 or more days and has not sought custody of the child during that period. Back in February of 2023, it appears, and we have documentation of this through the subsequent documentation of the court reports, that a very serious incident happened involving Mr. Schmidt. At the hearing in January was when high hopes were, well, when hopes were up. We had just named officially Mr. Schmidt the legal father of the child in January. He was fully engaged at the February hearing, making his way through services, as Ms. Berger referenced, but then it would appear in February, which triggered, by the way, some testimony about this from the grandparent of the child to come forward. But it looks like what happened was there was a very serious car accident where Mr. Schmidt was intoxicated. He had relapsed using maybe some substances. This is what we knew at the time based on the testimony that we had from the grandfather, and that he had lost touch with the department as well in February. So by April, we have a demonstration that Mr. Schmidt was less engaged than more engaged, even in the very first review period, even though he had made exemplary progress immediately in his services and looked on track for reunification. That particular incident happened. He did not join us for the April hearing, and the court did suspend his parental rights based on the allegations of how dangerous that had been at that time. Then in the next review hearing, in July of 2023, Mr. Schmidt had remained disengaged. We didn't really talk about him much, other than to say that he had not been engaged and had not been in communication with the department. And at that point alone, we were nearly at 91 days of abandonment. The court had not suspended his parenting time during that particular review hearing. I just looked at the orders to make sure of that, but rather issued a recommendation that a counselor should weigh in on any parenting time that was issued for Mr. Schmidt, which didn't matter because he wasn't asking for it. The question the statute asks is whether or not he has abandoned the child, not whether or not the department has abandoned the parent. And despite Ms. Young's efforts to re-engage Mr. Schmidt, he remained at that point in time, which is at least 5 months at that point, disengaged in all respects, including parenting time and visitation for his child by his own decision, not just.
Can you imagine if he had his kid with him the day that he crashed his vehicle while he was under the influence?
Simply because the court had issued that order suspending his visitation in April. And then, of course, you have the opportunity for him to request that counselor and visitation between July and September, which was our next review period. Again, he remained largely unaccounted for, off the radar, etc. In September 5th, 2023, oh, you know what? I do want to visit this. He did appear at that July 18th, 2023 hearing. I do recall this, actually, and he testified that he had denied that he had been intoxicated during the car accident, causing the court to raise some pretty significant questions about that. And then in September, part of the exhibits that were received into the record was the 2/24/23 Blissfield police report, documenting that unfortunately what Mr. Schmidt had tried to say happened at the last review hearing was incredible. The testimony of the grandfather from the initial hearing and combined with review of the police report does substantiate that in that February incident, Aaron Schmidt was found to be highly intoxicated in police contact around a car accident and a car theft. So
Car accident and car theft.
he had maintained appropriate housing through there. His last visit was March 20th, 2023, wherein he had made comments indicating he was stepping away, didn't wish to hear from the caseworker. And by his own testimony today, he confirmed that he had been significantly absent from his child's life. So I think with all of those pieces of information, we do have clear and convincing evidence by his own testimony given today that he had abandoned the child for a period of 91 days or more, making termination appropriate under MCL 712A.19B3A subsection II. The next subsection, or the next section to consider would be the 3CII. That specific language asks the court to review whether or not a parent was a respondent in a proceeding brought under the chapter, which he was, whether or not 182 or more days have elapsed since the issuance of the initial dispositional order, and the court, by clear and convincing evidence, finds that the conditions that led to the adjudication continue to exist, and there is no reasonable likelihood that the conditions would be rectified within a reasonable time considering the child's age. This is the one where Mr. Brooks's comments are very salient. However, as I look at the case, I see a situation at the outset wherein Mr. Schmidt was heavily reliant on Bailey Demansky, arguably to the point that he was not very involved in the child care at all, which perhaps was a contributing factor. She, of course, did plead guilty to child abuse at that time. In subsequent hearings, she's shared with us as part of her rehabilitation efforts how stressful it was to care for the high number of children that were in the home at that time. We heard then about how many hours Mr. Schmidt worked, as we did here today. So arguably, Mr. Schmidt's most involved time was the month or two during which he was engaged in services. And when I say involved, I mean arguably involved in his child's life whatsoever. It would appear from my perspective, frankly, that he's not been very well engaged as a parent before or since adjudication, with the exception of that short time frame during which we all, frankly, had high hopes that he would remain engaged and be able to be an appropriate and safe parent for his child. So that aspect of the neglect, as well as the need for counseling to understand how that could impact a child, how the abuse impacted the child, how to avoid dynamics like that in the future, were all part of the case services plan that were designed for Mr. Schmidt. He did engage in services around those, but then with his significant incident in February and subsequent complete disengagement from services, with the exception that I've explored today around some counseling that happened in November, certainly we do have a demonstration that there was no benefit from those services, and that the issues that were identified at the outset of this case remain barriers for Mr. Schmidt. There's no reasonable likelihood that those could be rectified within a reasonable time considering the child's age, regardless of the suspension of parental rights that was reflected in orders arguably from September onward. And that's because we've heard Ms. Caitlin Young testify more than once about her efforts to try to reach out and engage Mr. Schmidt, and his declination to do so. There's no reason to think that that would change in the future, frankly. Even after a meeting with Mr. Brooks and Ms. Young in November, he has continued to avoid any additional services for the most part, and has not sought a way forward on visitation. So I think there's clear and convincing evidence under that particular section as well. Under subsection G, the court looks at whether or not the parent, although in the court's discretion financially able to do so, fails to provide proper care or custody for the child. And there's no reasonable expectation that the parent would be able to provide proper care and custody within a reasonable time considering the child's age. Part of this, I always look at housing, which he has maintained appropriate housing to the best of the information that we've had during the reviews that we've been able to see that, as well as employment, if not constant, then at least significant at times, including today. Despite that, 80-hour work week, and the significant amount of hours he was working at the outset of the case, I've never heard any testimony, including up until today, that he has provided financially for his child. And he certainly has demonstrated quite concretely that he does have the financial ability to do that. He explained today that that was because he wasn't allowed to see his son, as if the child simply didn't exist if he wasn't there to see him. Unfortunately, that's not how that works. His child has needs on a daily basis that are being met right now by his parents, the relative placement, as well as the department. So I think there's clear and convincing evidence under this provision as well. And he's demonstrated over the course of these proceedings that he's not going to provide financially. And I find that that supports further that there's no reasonable expectation that he would be able to provide proper care and custody or support within a reasonable time, considering the child's age. Under subsection J, there is a reasonable likelihood based on the conduct or capacity of the child's parent that the child would be harmed if the child is returned to the home of the parent. I also find clear and convincing evidence here. And I think this one is the easiest one to see how the evidence all fits together. There is a serious risk of harm in turning over a child to a parent who wants to, needs to, has turned a blind eye to physical abuse in the home. To a parent who can demonstrate that he has some parenting abilities, but disappeared for a very significant period of time from this child's life, continues to be arguably disappeared, and that is a huge risk to this child if I were to return him to the care of his father. I have no intention of leaving this child in a situation where he could be physically abused, neglected, or abandoned at any point in time without any warning, even under the circumstances where he has the supervision of the department, the support of his relatives, and his attorney. So for all those reasons, termination is warranted under the statute. As it relates to the best interest determination, that has to be viewed as far as whether or not there's a preponderance of the evidence that this is in the child's best interest. Clearly, the relatives have provided for this child. The grandparents have taken care of the child. This is a relative placement, which under the law lends support to giving Mr. Schmidt additional time and opportunity, neither of which he's taken advantage of. This child's been in care for, I think, arguably nearly 2 years. 3/26/22 is when he was removed, and we're coming up on, unfortunately, on the anniversary of that. So he certainly has had an extended period of time to take advantage of that opportunity. Unfortunately, what happened was a fallout, similar, I think, in many ways to the abandonment of his child, was the abandonment of his relationship with his parents, which of course came with it, abandonment of those opportunities that come along with having a child with a relative, especially parents, frankly. So even though that was the situation, I cannot find that it's something that would hold up termination of his parental rights. He doesn't have a bond with this child. As I articulated earlier, I think that at best he had a pretty good bond for a couple of months when he was engaged in services, frankly, but it doesn't sound like he had much of a bond when the child was at home, and certainly not after he dropped all communication and indicated he wanted to walk away on March 20th, 2023. This child is very young, needs stability and permanency. He's receiving that in the care of his grandparents. He's been able to make leaps and bounds through his early on supports, and is doing well in their care, thanks to the stability and permanency that household is providing him, which is certainly more stable and permanent than, unfortunately, the home that his father would provide for him. We have the support of our LGAL in requesting the termination of parental rights, as well as our caseworker. The child is too young to really express a preference. The likelihood of him being adopted and adopted expeditiously has been documented on the record by the licensing efforts by the grandparents, as well as confirmation in more than one hearing that that's what their intentions would be, to support their grandchild. So for all those reasons, I do find also there's a preponderance of the evidence here that it serves the interest of the child. I would say is, as it relates to the argument that we may be looking at guardianship in the future, then I think Ms. Bailey-Domansky is going to be looking at some issues as well here, with the significant amount of time that she's had to be absent from her child's life, which has a lot to do with her criminal charges. So that's going to be part of the analysis that the court does when I look at whether or not to terminate her parental rights.
We call that foreshadowing.
In all fairness, to the child, which is the reason we're here. We need a permanent, stable environment. And we have that with a child who's very well bonded to these parents. And she's going to have some explaining to do as well about how that extended period of absence cannot support termination of parental rights without some significant defense. So I have to look at whether or not we are moving forward towards a permanency goal for this child. And at this juncture, adoption is the most appropriate. It is what the goal currently is, undisturbed from today's proceedings. And in order to do that, we'll need to free him for adoption. And part of that is termination of the parental rights of Aaron Schmidt, which the court will document in an order today, along with relief from the department to provide any additional reasonable efforts or to avoid further removal. We will be mailing out the orders to Mr. Schmidt to appeal if he so chooses. He'll have 21 days to do that, with the court supplying an attorney if you're unable to do so financially. And we will require you to show financially that you are unable to afford your own attorney. Arguably, throughout the proceedings that have been here, with you working 80 hours a week, there's really an action there from the public defender's office, frankly, that potentially could be instituted, and I'll reserve that to them for reimbursement of attorney fees that have been provided as a result of the public defender's office stepping in where Mr. Schmidt declined to find his own attorney. We'll also be sending him some information about keeping his identifying information current with the Central Adoption Registry, including his right to file the denial of release of that identifying information or to update it as he so chooses. We'll have 21 days to execute that request for attorney and appeal. The case will carry on to the next court date scheduled in April for an additional review and hearing on the termination trial as it relates to Bailey-Domansky on April 23rd, 2024 at 1:30. Unless there's any questions, that's all.
Wow. And then we go on to the hearing that we saw from April 23rd, I believe it was, and which we watched just a couple days ago. So there's the update, y'all. I promised I would come through for you. I did. Well, Lucy came through originally. She's the one who got me going down this rabbit hole. And then I went and I found his hearing after I'd chronologically ordered all of hers and got them edited, and in one of them I heard the date for his and it was like, oh, I guess I'm gonna go find that now. And I'm really sad that I wasn't able to get the 9-5 hearing or the sentencing. What do you want, baby? What do you want, baby? What? Do you realize that I'm live? Or you just gotta go potty again? You gotta go potty? Is that it? You gotta go potty? All right, guys. I know. Okay, so yeah, I'm gonna do this real quick. All right, in the Discord, there are a whole bunch of games you can play. We've got the chats set up where there's the voice chat rooms. Ava's place, you can go in there and play all the games and stuff. And and I now go in and I'll play checkers or golf, which I wasn't good at. Poker, I wasn't good at. Pretty much the only thing I can do is checkers. I'm good at that. Aren't I, Philip? And there are instructions in the Insomniac chat for how to link your YouTube account to it. And the benefit of doing that is at some point, we'll have kind of like members only streams like we do on YouTube, but it'll be linked to the Discord at the different levels. So that'll be fun. That'll be lots and lots and lots of fun. So I highly recommend, encourage everybody to go and do that. Get your YouTube linked up with your Discord, and then play the games. It's so much fun. And they even have solo games, or you can play against the computer. So you know what? If you're bored and you need to kill some time, and you don't want to be on the Heck Book or any other platform or whatever, you can just do that. Come on into Ava's place. If other chat members see you in there, they might come chat with you. Nobody has to have their camera on. My favorite part. That's why I like going in there during the days, because I don't have to have my camera on. I don't have to get ready. I don't have to care. I can just show up. But yeah, and I'm sure there's more to come too. Yes, okay. Go into a voice channel and hit the rocket ship, and that'll allow you to see the game menu and start playing and stuff. So yeah, that's the Discord thing that they've been talking about all night tonight. And then I heard from a little birdie, that you can do almost everything on X that you can do in Discord as well. So, and tonight was the first night streaming on X, and I know we didn't have a lot of people in the chat from X, but I also know that we do have several viewers that are watching from X. And I know that because I have 38 people on my little eyeball right above me, right here. There's an eye, and it says 38. But when I go onto the YouTube app, that's not 38. There's 24 according to the YouTube app. So I know we've got X viewers. Oh, hey, somebody just logged off. No. So anyways, guys, I gotta take puppers out. But thank you all for coming out. I'm gonna create a playlist and put these two together. Because who knows, maybe I can find something else from this whole shenanigan. Oh, I did not like this case. I didn't like it. I'm just really glad that the little boy got put with his paternal grandparents, because let me tell you, that granddad, that grandpa, he's such an amazing human. And there's nobody in this world who's going to love and protect that boy more than that man we saw. Don't get me wrong, the grandma's tops too. The grandma is tops as well. But that grandpa, yeah, he was something special. All right. Yes. Thank you, everybody, for joining us. For those who are still awake, I know I was cutting it close a few times. I was struggling there for a minute. But you got to figure, though, to be fair, I've seen the case like 3 times now. because with editing and harvesting it and everything else like that, I've watched a few times, so I knew what was coming. And so, so I was so tired because I've been up since like 6 a.m. And I was starting to get dozy, and I'd be like, okay, I'm just gonna close my eyes for 1 second, close my eyes for 1 second, close my eyes for 1 second. Oh, I'm here. So, but that's what I get. That's why I wanted to start earlier, but it took forever to export it. By the time it got exported, I was like, I've got like 15 minutes if I want to get on at all earlier. So, yeah. Yeah, I'm glad I went on right away and I didn't wait until the regular time, or it would be like 3 something in the morning right now. And yeah, I definitely would be asleep. So thanks again, everybody. And I will see you all very soon. I got some good stuff lined up for tomorrow. I just got to get it edited. That's like the story of my life. Wake up, edit, harvest dockets while editing, take the dog out, feed them in the meantime. It's my life right there. Whole thing. Everybody, be safe, be well, sleep sweet, and much love.